let's do this. All set, Fran.
All right, good evening. This is Fran Backstrand, the chairperson of the Northborough Zoning Board of Appeals. And we are opening our September 27th Zoning Board of Appeals meeting. It is beyond the hour of 6 o'clock on the 27th. This open meeting of the Northborough Zoning Board of Appeals is being conducted remotely, consistent with the Governor Baker's executive order of March 12, 2020, due to the current state of emergency in the Commonwealth due to the outbreak of COVID-19 virus. In order to mitigate the transmission of the COVID-19 virus, the town of Northborough has been advised and directed by the Commonwealth to suspend public gatherings, and as such, the governor's order suspends the requirement of open meeting law to have all meetings in a publicly accessible physical location. All members of the Zoning Board of Appeals are allowed and encouraged to participate remotely. The order allows the Zoning Board of Appeals to meet entirely remotely so long as reasonable public access is afforded so that the public can follow along with the deliberations of the meeting. The public is encouraged to follow along using the posted agenda unless the chair notes otherwise. Members of the public who wish to view the live stream of this meeting may do so by going to Northborough Remote Meetings on YouTube via the link listed on the agenda. Ensuring public access does not ensure public participation unless such participation is required by law. This meeting will feature public comment. Okay, so we are off to the races. So, all right. Oh, hey, Mark.
Now it should be high.
Yeah, okay. And I apologize. The camera on my laptop is starting to fail today. I must have used it too much. So to start, we are going to start with the continuation of the consideration of the petition of Berlin Landing Realty Trust for an appeal to build a daycare center with an associated parking lot, which will be leased to an appropriately licensed entity on the property located at 5 Barefoot Road, map 30, parcel 33 in the industrial district and residential C district. And this continuation in part was due to competing interpretations of a case law regarding the use of the Dover Amendment and or the reasonableness of our zoning. So we do have the town council, Attorney Donetsky, with us this evening so that he can maybe give us a layman's version of the legal interpretation that he has provided for us in writing.
Thank you. Good evening, board members. There was a memorandum that was distributed earlier today. It's lengthier than I would have liked, but I wanted to try to be as complete with respect to the pieces of this puzzle, if you will, which include where we start, the industrial setback, as I've called it in the memo, which is the 100-foot setback for industrial uses from, in this instance, a residential district. Also included the provision in Section 3 of the Zoning Act on which the appellant is relying, that similar to the language for nonprofit educational and religious uses, provides protection for childcare facility uses. And there are two rather lengthy definitions. I would have otherwise excluded them, but I wanted again to give you a full picture. I don't believe that we need to parse through those because it doesn't seem to be that there's a question about the particulars on that component. So one of the main principles in dealing with the protections that are provided under Section 3 is that each case must be considered on its own particular facts. There are more cases simply because the language in the statute is older that deal with the religious and educational use protection than there are for the child care facility protection. With that said, the general principle is that the specific facts of a particular circumstance will be the main guide or roadmap for evaluating whether a particular reasonable dimensional regulation under a zoning bylaw may be applied. And put simply, it's whether it is something that will serve the purpose that is either evident or may be inferred from the bylaw in question. And so here we have a setback that relates to industrial use when it is abutting a residential district. And the use that we're dealing with now, though it be proposed for the industrial district, is a use that's allowed in all districts under the zoning bylaw because it comes under the classification of an exempt use. The bylaw provides that there are two types of exempt uses, those that are designated in Section 3 of Chapter 40A and those that are municipal uses. So this particular facility that's proposed would not be classified and is not listed in the table of uses as an industrial use. So the question is, if it's a use that could, as of right, be established in a residential district, does the setback distance that's designed to separate industrial uses from residential uses need to be applied? Does it serve the purpose of that separation in this particular instance? And for the factual basis, again, it's an allowed use, and the setbacks that would apply to that use in the residence district are actually slightly less than those that would apply in the industrial district. And on that basis, it's my view that there is a legitimate basis for the appellant to say that the statute does provide the exemption from that industrial setback, and that a court could well find that the statute does operate to that effect. So that's in summary the background and the basis and the opinion that I've provided.
Okay, well, thank you very much. So just so that I can recap, the original determination by our zoning enforcement officer that the 100-foot setback between industrial and residential is fair and legitimate. The applicant is indicating that because the use would otherwise be allowed in residential, that setback is not necessary because it's not preventing industrial use encroaching on their properties. Correct?
That's my view, that it doesn't serve that purpose in this instance, right?
Okay, all right, okay, thank you. All right, so board members, do you have any questions specific for the town council?
If I may.
Absolutely, Mark?
Okay. Is there any, since the people who bought in the residential properties that border this had an expectation that there would be a 100-foot setback to any construction on that industrial property, do they have any say in opposing this, that they can make the argument, we bought our property with an expectation of a 100-foot setback to any structure, and that's not what's happening here, so that their rights are being violated on that?
I wouldn't say that their rights are violated, only because if it was presumed that it's an industrial use that would have a 100-foot setback, that would be a fair expectation based on what's in the zoning bylaw. This zoning bylaw, along with any other in the Commonwealth, would also be subject to any of the particular provisions or protections that are in the Zoning Act. So while it may not have necessarily been presumed, or someone may not have thought it likely, I don't see that there's a statutory violation if that exemption is implied or applied, excuse me. Now, again, as has recently happened, if there's a determination that the board makes and someone who is within the statutory abutter classification under the Zoning Act wanted to appeal, then that conceivably could go forward. But I don't see just the fact that the Zoning Act provides protection and the bylaw has a 100-foot requirement as depriving them of any particular rights.
Mark, follow-up or are you?
No, that
Okay,
clarifies.
okay. Does anyone else? Leslie, Jeff, Dick, Brad, Paul? Staff need any? Oh, good. Dick?
I have a question. This land is basically, a large portion of it is unusable. It's 2 acres of land and most of it's underwater. And the applicant has tried to use it for other things, duplexes in the past, and has been denied that. And now it's before the board because of the setbacks, and he's trying to put the daycare facility in there. And the property is at the intersection of Barefoot Road and Solomon Pond Road. And on the opposite corner of the intersection is a piece of property that just sold in March of this year for $300,000, and it's 2.3 acres. Now, this property sold in, I believe, 2015 for $10,000. So obviously it's a piece of land that was unusable, and now it's before the board as this exemption. And I was wondering if there's any case law about unusable land trying to get into this exemption.
There's no case that I'm aware of that addresses the issue as it presents itself and as you've described it. I think that the value of a purchase would depend on the knowledge of both buyer and seller, and sometimes prices are different from what others might expect, either at the time based on information known or in light of information learned after the fact.
If I may.
Sure, Mark.
Okay, earlier they had applied to build a residence on this piece of property. I guess following your logic, it seems that we had no reason to deny the construction of a residence, because if it's usable as a residence, then once again, the 100-foot setback doesn't apply because it's using as a residence, not an industrial use. And therefore he should have been able to build his house on it instead.
I would not go that far, because in that instance, we wouldn't be dealing with the Section 3 protection and the case law that has come down over the years interpreting that. We would simply be dealing with what the bylaw says with respect to construction in the industrial district. So I would consider that a hypothetical at this point and a question I did not answer, but I would not say, based on the information I have, that it was incorrect for the 100-foot to be previously applied to a proposed residence.
Okay.
Because there is a slightly different definition of reasonable when you're talking about Chapter 3 or 40A.
Madam Chair, if it were only a residence proposal, we wouldn't even get to the 40A Section 3 question.
Mm-hmm.
All right, thank you. Okay, all right,
So Madam Chair, if I may.
sure.
So I appreciate your interpretation and thank you for clearing that up. One of my questions, though, is reading on the Dover Amendment, it was more about not to circumvent zoning bylaws. It was more to prevent discrimination of religious or not-for-profit organizations from doing business in a certain town or on a certain parcel of land. Originally, we were told this was going to be a not-for-profit, and then during the hearing, they decided it was for-profit. How can you give me a little more clarity about your interpretation as far as religion, not-for-profit versus for-profit, and just trying to circumvent zoning bylaws in a specific town?
Sure. The nonprofit component is an element in the protection for religious and educational uses. That's not a requirement when you're dealing with the childcare facility language. So it's not applicable if one is proposing or seeking the protection under the 3rd paragraph of Section 3. The nonprofit component applies to religious or educational. They're two separate protections, if you will.
Okay. I don't think I asked my question correctly, but get back to me in a minute, Madam Chair, if you don't mind.
No,
If
not at
there's-
all.
Take any other questions in the meantime.
Okay. Does town staff need any clarification while we have the attention of town council? I see, Bob.
One question, David, and thank you for coming tonight. If the 100-foot setback is not applicable in this case, do we default to the standard setbacks that are published in the zoning bylaw in the chart?
In my memorandum, I said that with the exemption applicable, the setbacks that would apply would be those that are specified in the industrial district, which I believe are the 40, 20, and 25.
Right. Okay.
Okay. Leslie or Jeff, you're welcome to ask questions as well.
Excuse me, I'm all set, thanks.
Okay. Brad, one more time?
No, thank
Oh,
you.
I mean, if you want, you can just say the question again and just see if it comes out differently. 'Cause it's
Yeah,
hard
I mean,
sometimes
just-
to figure it out.
Yeah. I mean, well, here's a follow-up. I mean, is this going to set precedents throughout the town there where organizations can circumvent our bylaws and just say Dover Amendment and say the 100-foot setback is moot, or side setbacks and things like that? That's one of my concerns is, okay, if this goes through, are we opening up Pandora's box for other issues down the road?
I wouldn't say that any particular application under these exemptions in section 3 sets a precedent, because the case law is pretty clear that each case has to be considered on its own particular facts. The statutory protection does exist, so it is open to any property owner who would propose one of those uses that's protected to seek the protection. Now, if we had a situation where there were a much larger lot, for instance, and the 100 feet or any particular setback requirement that might be applicable to a proposed childcare facility could easily be met by an applicant, then I think the case for an exemption would be much different and much weaker.
Okay, thank you.
So before we let you go, just to recap, it is in your opinion that the intended purpose of the 100-foot setback is to protect the residential from industrial use development. In this instance, the daycare is an allowed use in residential and would not require a 100-foot setback if it was within the residential. Therefore, the separation doesn't serve the purpose that was intended in the zoning bylaw.
I would agree with that brief summary, yes. And I'm comfortable if the chair wishes or the board wishes for me to remain as you discussed, but whatever your pleasure.
Kathy?
Fran, I just want to remind you that this is the continued public hearing,
Mhm.
and I think that all the applicants are on, whether or not they want to participate in this part of the discussion, because it is all part of the public hearing.
Oh, absolutely. So, I mean, I can certainly open up to the attendees. I guess I just need clarification as to whether or not I don't want this to get into a litigation conversation between two lawyers, but how much of that is, should we expect or accept? I don't.
Well, I'm thinking you're probably not going to get any pushback from the applicant
Oh.
at this point,
Okay.
based
right.
on the conversation.
Okay.
But
But, all right, so let me see who from the applicant is in, if the applicant and or their representation can.
yeah, I believe you've
put
got
a hands up.
I believe there's Scott Goddard,
Okay, one
and
second.
Nisha.
Oh, okay.
Nisha
Okay,
is with Fletcher Tilton.
okay, so 1 second. All right, I see Nisha. I'm going to allow you to talk, Nisha. If you can just give me 1 second. I don't see a Scott Goddard.
I see Scott's hand is up.
Fran, he is at the top of the list there.
Oh, well, all right,
and
so,
has his hand
sorry,
up.
I was looking alphabetically. My apologies. Okay, so Scott and Nisha, do you have anything you would like to add, share, or contradict?
This is Nisha here. I don't know if you can see me because I can't see myself, but which is fine. I don't really have anything to add. I really appreciate Attorney Dineski taking a look at all the cases that were cited by myself as well as by Attorney Bassett. And I think it's in keeping with what I've suggested to the board as far as our interpretation goes. So I agree entirely with that analysis and how it applies to the particular project here.
All right, thank you. Mr. Goddard?
I have nothing further to add.
Okay, thank you. All right, so this is a continuation of the public hearing. So I would ask if you have interest in speaking to the board, raise your hand. I will try my best to get people as they do. And just remember that, just as a reminder, we have a full agenda tonight. So I'm going to ask anyone who has spoken in the past not to feel they have to repeat what they've shared with us last week, because it is all part of the record and we can always review the tape if need be. And just if we could just keep our remarks brief and to the point. Okay, so I'm going to go down. I see there's a Mary Bassett. So I'm going to start since you're the next person in line. You just need to unmute yourself, please.
Thank you.
Thank you.
And just very briefly to the board, I think each case does have to be considered on its facts, and I think the board well knows the facts of this case and the status of this lot. I think there will be a precedent set. I believe the facts show that this lot is only buildable with this exemption because of the size, the shape of the lot, so that, you know, the exemption is to build something. And of course, whether or not the opinion that this use is not like an industrial use, we don't know anything about this use because of the, you know, all you have is a footprint that you're working with. And I really say that, you know, the language has been parsed quite a bit tonight. And I will just conclude by saying that I think that the court could also find that the enforcement of the bylaws as they stand, that all your residents of the town of Northborough that have relied on these bylaws, and it's not like they're asking, oh, could we have 20 feet? Can we have 30 feet, 40, 50, 60, the whole thing? I don't think that's fair and reasonable. So I think the court could find that enforcement of it does substantially protect an important governmental interest. So I think it comes down to the board, you know, how, I don't think anyone knows how the court will decide. I think the board should decide based on what you have been elected to do, you know, for the people and the residents of the town of Northborough, and the court could go either way on it. Do the right thing. That's all I ask you. Thank you so much for the few minutes.
Thank you. Okay, so let's see if I can do. All right, the next I'm going to have, I believe, and it's Carrie Weber. And if you could just state your address for us, please, Ms. Webb, Mr. or Mrs. Weber, sorry.
Yes, hi, it's Carrie Weber. I'm a resident, 7D Pondview Way, one of the units opposite this parcel. So I've been a 9-year resident here, taxpayer. The taxes are not low in Northborough. We are looking to the town government to, you know, serve the people, the taxpayers in this town. this particular parcel is a buffer between residential areas and industrial areas. And it is instrumental to the quality of life that we have here at Pondview Way. And I believe it will adversely affect property values to have half the trees knocked down and to have a building put in there on spec, mind you, because he doesn't actually have a tenant in this point. The building could sit abandoned for a while. We don't actually know. He doesn't have a tenant. I believe this is really, really detrimental to the quality of life, particularly here at Pondview Way, but it's also really not good for the residents of Northborough. And I feel that the board should do their due diligence and do what is right for your taxpayers who are paying for you. Very much opposed to this. This proposal would ruin this neighborhood. Thank you.
Thank you, Carrie. Okay, next I have Bill Donovan. If you could also state your address, please.
It's Bill Donovan, 3B Pondview Way. And just to reiterate what Carrie said, and I do appreciate Town Council Vineski's input and the great questions that the board brought to him. And keeping it short, I do agree with Carrie. Many of us have lived in this complex for 10, 15, 20 plus years. The tax rate here in Northborough is what, 17.25%, 17.5%. And what we do expect for that high rate, because we do have limited services here. No snow removal in the winter, no road repairs. We have to flush our own fire hydrants out of our budget. So, you know, we are limited to the town services with that high tax rate, but we do expect that the town look at the issues that the residents bring to it, the conservation, the zoning, the planning, and you know, just really look into this proposal that this individual, this purchased the land for less than the used vehicle price, and now wants to make a fortune, and it's just not applicable in this situation. And I really think the town needs to look at the taxpayers' concerns. Thank you very much.
And thank you very much, Mr. Donovan. Okay, I just need to ask real quickly our IT person. When the people that were invited to speak, when I wanted to unmute them, I thought I was putting them back into as attendees, but I don't see them now. And I just want to check before I do it to Mr. Donovan, when I try to remove them from the panelists, am I knocking them off the webinar? Because I don't see them now on here.
I don't see them either, but no, you're doing exactly what you should be doing. You should be allowing them to talk as attendees, not
Right.
bringing them in as panelists. And
So that's what I'm doing.
Yep, you're fine.
Okay, all right, so I think I did accidentally delete them somehow. All right, well, hopefully they'll call back. Okay, all right, I don't see any other hand. Oh, one more hand raised, I apologize. Okay, so this is Mr. Harnett. Again, if your address, please, and unmute yourself. Please.
Okay, I think I'm unmuted. Can you guys hear me?
Yes, we can.
Yes,
Thank you.
hi. Return it, Unit 1A, Pondview Way. Not to repeat anything that Mary or Carrie or Bill has repeated, but just to add to that, I think, you know, the other implication here also has to do with traffic and accidents that have continued to happen at the intersection of Barefoot and Pondview are very frequent pre-COVID when there was more commuting. But most recently here in the summer, there was an accident that took out the guardrail right in front of the entrance to Pondview Way. And putting a childcare center is obviously detrimental to our property value, but also I think detrimental to the people that would potentially use it for bringing children to a daycare center. And that should also be taken into consideration.
Thank you very much. Okay, I do not see any other hands raised. Does anyone, any staff and or board members have any other questions or concerns regarding this?
Chairman,
Sure, Paul.
sorry, Madam Chair, I just
No
have one
worries.
last, just a question for town council, if that's okay.
Sure.
So the Dover Amendment was enacted in 1950 in response to local zoning bylaws that prohibited religious schools within a town's residential neighborhood. The law was intended to protect religious and nonprofit educational agencies from discrimination. Now, the town of Northborough, our bylaws are not discriminating against any sort of religious institutions or educational agencies. So this applicant can go anywhere within Northborough, right, and build a nonprofit school. Right, it just so happens that this one is in an industrial zone. So there's really no discrimination, right, against him building within the town of Northborough. So,
Oh, you're muted, David.
Pardon me, we're not dealing here with the religious and educational exemption component of the statute, but rather with the child care facility component. And it's a different formulation with respect to one, the nonprofit aspect, as I mentioned earlier, and it's newer language. Obviously, as you point out, Dover Amendment has a much longer history and derives, again, as most probably know, from the town of that name. But the statutory protection for a child care facility is law, and it's not so much a question, and in this instance, not at all a question of discrimination against a religious or educational use, but rather the legislative determination that child care facilities do have heightened protection under the Zoning Act.
okay. That's all.
All right, thank you very much. Okay, so if there are no further questions or concerns for either town council or regarding this application, do I hear a motion to close the hearing? Oh, somebody has to unmute.
I make a motion to close the hearing, Madam Chair.
Thank you,
I'll
Brad.
second.
Mark seconded. Okay, we'll do a roll call. Brad,
Aye.
Mark,
Aye.
Dick,
Aye.
Paul,
Aye.
and Fran, aye. Okay, so the hearing has been closed. We will discuss it at the tail end of our meeting this evening. And I thank you everyone for participating. Okay,
Thank you.
thank
Thank you.
you. Okay,
Take care.
bye. All right. So when they hang up, they should, there we go. Okay.
Thank you, Dave.
You're welcome. Good evening.
Thank you, David.
Thanks for coming.
And, all right, so the next item on the agenda is the continuation of the consideration of the petition of the New Bridge Granite Corporation for a variance special permit with site plan approval special permit, groundwater protection overlay district to allow the finishing of marble and granite countertops and related items to be in a showroom to display and sell them on the property located at 329 West Main Street in the Business West District and Groundwater Protection Overlay District. Okay, so a couple of things as we start out tonight, just to keep us on the right path here. I just want to make sure that all the members of the zoning board received the letter from our town engineer recapping the groundwater advisory council and as well as his review of the question that was posed by, I think, two of the board members to him regarding the entire project, the 329, 333 site plan. And we also had, let's see, okay, we have a couple of letters and such. I do want to just to make sure that we stay clear tonight that the New Bridge application that's in front of us tonight is solely because it's in the groundwater 3 overlay district and the use of chemicals that were going to be within the new granite business. The Groundwater Advisory Commission has issued their recommendations, which the applicant has agreed with. So we have their recommendations, we have what their concerns were, and this was specifically due to the groundwater overlay district. Any questions or concerns about the entire property are not applicable in the same way they are to the appeal that is being heard later next month. The granite countertop use is an allowed use today. It has nothing to do with the 1987 special permit that is in the appeal stage due to the interpretation of the contractor's yard. Today is just about the granite countertop sales, which is an allowed use by right, and is the preparation of the countertops is an accessory use of that sales. And we're really going to try to stay focused on the groundwater 3 overlay district that triggered the special permit with site plan approval for this business. I know that there's an appeal pending for the entire thing that's going to be heard later this month. It has to do with the zoning enforcement officer's determination that the use of the contractor's yard that was originally permitted is still applicable. But tonight we're going to stay focused just on this one actual corner of the building, because that's what's before us. This applicant, as well as the owner of the property and anyone else, any other tenant, are taking the risk that whether we grant this special permit or not, if the appeal is upheld, they're all going to have to vacate anyway. They understand the risk. Our role tonight is to look at just this application and try not to get down the muddy waters of the appeal, which we're going to hear later next month. So that being said, let's see, who do we have for the applicant? Kathy, please.
You would have Mike Norris, attorney Michael Norris, and
Okay. Allow to talk. Okay. And Attorney Norris, is there anybody else with you that you're aware of?
I believe my clients are also with me.
Oh, right.
Sebastian.
Yeah, Patricia, right. And Patricia, is your husband also on the same line as you?
Yes, hi, we are here. Thank you.
Okay, and remind me again, what is your husband's first name?
Sebastian?
Sebastian.
Yeah.
Okay,
and Fran, maybe not to be brought in right now, but there's also Mr. George Connors, attorney
All right.
George Connors.
Okay.
But
okay.
again,
But he-
that's
right.
on the bigger project.
Okay, and then I'm just going to go back to our IT person in the back. I still see 2 people as part of my group. Is that okay? There's a phone number there that I don't remember inviting in.
I'm sorry, you see this where, Fran?
There's the phone number that ends 265.
Yeah?
I don't know how that got in there, and Mr. Donovan is still part of our panel.
Okay.
And I don't want to accidentally
Yep, understood. Please
get them.
give me just a second. So phone number ending in 265. Just going to disable. I'm going to mute them for now.
Okay.
Okay. And then I'm sorry, the other
Bill Donovan.
all set. Thank you, Fran.
All right, I apologize everyone for that again. So anyway, all right, so here we are. And the reason for the continuation, Kathy, if you want to just give us a brief recap.
Sure. At the end of your meeting last week, or at the end of this particular hearing last week, you had some outstanding questions that you wanted to have the town engineer and also the building inspector take a look at. You requested that they go out to the site and look at the location of the floor drains. You also wanted to just re-verify with Mr. Litchfield about the groundwater advisory committee's review letter and their review and recommended approval of the project, and then the site plan for the entire site, which is a project that Bob is working on with the owner, not with this particular applicant, but that was provided as a site plan for you all to look at, and Fred had not done a review of that as he was on vacation last week.
That's right.
So
Okay.
I believe that those were the 3 outstanding questions that you had.
Okay, thank you. So the letter that we got from Fred today is his review of the walkthrough with Bob, as well as to recap some of the groundwater advisory council's recommendations. Okay.
Yes,
All right.
correct.
So I realize that people got this kind of late. So I think I'm just going to ask Fred if he wouldn't mind just walking us through it a bit to give us a sense of what are the concerns that we should have, what concerns should we have regarding this and what should we not be concerned about? Okay. Thanks, Fred. If you unmute.
I am unmuted. Thank you. Again, I apologize for the late letter, not the vacation. Bob and I did go to the site yesterday, and we did confirm that there were no floor drains in the portion of the building that is to be leased to the Newbridge Granite Corporation. I believe that addresses one of your concerns. The other concern regarding the site plan for the entire property that was submitted by Cornerstone Engineering, I believe was in response to the building inspector's request that they verify that the site was in compliance with the original 1987 special permit. My review memo has a number of items indicating where the plan is deficient and not really a proper as-built plan. It doesn't show everything that it should show, and it doesn't confirm that the site is in complete compliance with the 1987 permit. But I also don't feel as though that plan is pertinent, in particular to the Newbridge Granite Corporation. When the groundwater committee reviewed the site, they looked at the four walls of the space that was being leased to the granite company. They did provide a list of chemicals. They did provide containment. They did confirm that there's no floor drain, so therefore there's no concern of a tight tank necessary for that portion of the building. And they did agree to recommend a waiver on the statement by a qualified expert indicating that there'll be no impact to the groundwater, the underlying groundwater, because all the chemicals that they would store for their business are stored within a cabinet that has containment, and therefore there's no chance for them to get into the groundwater. Let's see there. Why don't I open it up to some questions there, see if there's any. I don't want to go down the letter because it talks about a lot of stuff that's on the site plan about utilities and things that's not really pertinent to the granite business. But if you have some questions regarding the letter, I can answer them.
No, right. So I do
maybe go
appreciate
from there.
it's better to get targeted questions so that we can, look at the pertinent pieces of it. So I'll start with board members. Do you have questions? Again,
Madam
about-
Chair?
Yeah, sure, Mark.
Fred, did they clarify with the chemicals on how large any unit of the chemical is? I mean, are they coming out with a pint bottle, a 5-gallon pail, a 40-gallon, whatever?
They had a list of chemicals, and again, I apologize, I don't have it all committed to memory because it was back in June.
Yeah,
But they had a list of chemicals, and we agreed that the cabinet would contain a minimum of 45 gallons. And so that's the information that we're working with, is that's the maximum amount of chemicals, according to their list, that you would allow them to have on site.
Yeah, but I guess my feeling is, as far as getting into the groundwater, if they pull, as I say, if they pull a pint or a quart out of the cabinet at a time for working, that's a big difference between that and pulling 5 gallons out. Do we have any idea of how much they use at a time?
Maybe we could ask the applicant to answer that.
We could. I can.
Okay.
You can ask the applicant. He did give us a list. I've just got to pull through and find it.
All right, well, while he's looking for the list, Sebastian, can you give us a sense?
How much you're gonna be using?
Well, the cabinet, it is for 45 gallon, but we only gonna use like a 10 gallon because, we work with a small amount of sealer, small amount of 100% silicone, and most of those products I will have that on the truck because I use them on a Cosmo house.
Right. So, but the question is, while you're working in the back of the shop on a piece of granite, would you pull 10 gallons at a time out to work on that granite, or that's all you think you're going to have in the cabinet?
No, definitely not, because we use only like a quarter can of sealer. Then I can spray that on the counter and put it back. I'm never gonna use like 5 gallons or 10 gallons at the same time.
Okay, thank you. All right.
Can you tell us what the size of the can is? Is it a gallon can?
It's a quarter.
Okay, thank you.
Thank you, Mark.
So I have the list, Fran. I can run down the list for you. There was item called Nitro One Shot that they buy as needed. It doesn't indicate the size of the can. There is a grand quartz silicone that's used at the homeowner's site, so it's not used inside the warehouse or the manufacturing portion of the business. They have Rust-Oleum 1 gallon kept on premises. They have attestation. I'm not quite sure. It's a buy as needed, but it's very little left over, and it comes in small tubes, a few ounces. Then there's a Abaco, which is the dehydration system. As I understand it, when they explained it to the groundwater committee, they have a water saw that cuts the granite and creates a little bit of a sludge, and it's mixed with water, and the high pressure is what they use to cut the granite. And then there's a trough that's installed around the saw, and the water is recirculated and used over and over again and not discharged anywhere. And then there's small amounts of sludge that are removed off-site. They have some bonder that comes in a box with 12 tubes, again, a few ounces per tube. And then a small can, he doesn't say what, it's actually a 1 gallon can of epoxy that's used again at the homeowner's site where the installation takes place. And then there's a professional impregnator sealant that comes in a 5 gallon can that they would use to seal the granite. So the largest chemical that would be contained in one container is 5 gallons.
Okay.
Fred, one of the questions that was asked by one of the residents is that, is there, I'm gonna just read it, a provision for appropriate spill remediation is in place based on the MSDS? I don't know what that acronym is.
Well, the MSDS is the acronym for Material Safety Data Sheets, and material safety data sheets were supplied for each of the chemicals. We're trying to make sure that there wasn't anything that could be considered toxic to the groundwater. There's no chance of it getting into the groundwater without the floor drains. There wasn't anything of significant hazard. There's always, there's always some hazard. The chemicals are not all completely liquid. The tubes are somewhat liquid, somewhat solid, kind of a jello-ish state. Sorry. And the MSDS sheets are required there for each chemical when they submit them. So I believe they're in conformance. I also believe there's an additional permit through the fire department if and when a building permit is issued for the site, that they would then look at them in closer detail on how they're stored within the building.
Okay, thank you very much, Fred. Okay, board members, any additional questions or concerns for either Fred or the applicant and or their attorney? Kathy?
Yeah, Madam Chair, I have a question.
Sorry, Brad. Yep.
So one of the things that came up last week was the site plan and the additional impervious coverage if 333 is paved. And I don't want to go down a rat hole, but I mean, what is your assessment of that? Not necessarily the chemicals inside the building, but the additional impervious coverage for 333 when it's so close to conservation land.
Well, first of all, the additional pavement is not a result of the Newbridge Granite Corporation's proposal. So
Mhm.
it's a separate issue to be dealt with the overall site plan. In the letter, in the first paragraph, I outlined that I reviewed that site plan as it pertains to the entire site, not the Newbridge Granite site alone. While we were at the site on Monday morning, we did observe some vehicles parked on a gravel surface, which we don't typically allow. And in the memo, I indicated that if I don't know if that's out of convenience or necessity because of a space limitation, but if additional paving is necessary, then they should have to go back to the Groundwater Advisory Committee and get a special permit to enhance the amount. I do believe the drainage system that's shown on that plan, again, it's not pertinent to the granite, but the site plan that was presented by Cornerstone that shows additional pavement over the septic system has additional drainage that is captured with catch basins and drain manholes and run through a water quality separator before it discharges to the detention basin in the front. It does not propose any infiltration, but it does provide adequate water quality structures for that portion of the pavement that's added. So I don't see it as a detriment to the conservation land in the front, but it is appropriate, but not necessarily for this discussion tonight.
Okay, thanks, Fred.
So I just follow up on what your answer to Brad just now. We typically don't allow it. So what do we do now that they're doing it? I mean, is there recourse if the truck, whether they don't have the space or it's not convenient, if it's not allowed? I mean, or we don't. I guess what do we mean by not typically allowed? And is there any recourse to tell them they have to move them onto pavement or move them to another location until this whole site plan is resolved?
I believe the building inspector has already issued a letter to the owner of the property advising him to remove the trucks from the gravel area.
Excellent, thank you. And Bob, can you confirm that? That's a nodding of the head from Bob. Thank you. Okay, that's great. Thank you. All right. Okay, any other questions or concerns from Paul?
Yes, so so what we're looking at as it pertains to Newbridge Granite, right, is a special permit with site plan review. And do we need to look at this newly updated site plan review as applicable to Newbridge Granite, or can we revert to the original site plan review, which is a very basic one that shows just the building, right, and is more focused on the Newbridge Granite? Can we just look at that as the site plan review for this application only?
I believe you can. I think that the site plan, as it's called, is a generous term, I think. But the one bit of information that's on that site plan is the area of the portion of the building that Newbridge Granite is going to occupy, and that's 4,143 square feet. The only thing that pertains to the outside of the building that comes to the Granite Company is to make sure that they have adequate parking, I believe, for that portion of the building. And since we don't have we have a number of parking spaces that are shown there, I think that if the board is agreeable to the special permit for groundwater for Newbridge Granite, they could restrict, or they could require the applicant to get 13 spaces. I believe it's 3 spaces per 1,000 square feet of area that they're leasing, that they would require a total of 13 parking spaces, and that if they have 13 dedicated parking spaces within that overall site plan that are just for Newbridge Granite Corporation and adequately signed and shown on a plan in perpetuity, that those are the ones that go for that building, that the rest of that site plan is really for the remainder of the 329 building, and it's up to them to verify that they have adequate parking. Should they not have adequate parking and require additional impervious, again, I believe that would be an additional site plan that would be submitted, and that it would go before you as an amendment to the original permit, and then also to the Groundwater Advisory Committee for an increase in the impervious cover.
So, Madam Chair, I guess my
Yes.
next question is, do they have sufficient parking as the site currently exists? They do.
I believe they do. I believe that the building inspector's interpretation of the building is that it was, it had it at the last time it went before the approval.
Right.
It's only if they want to expand the amount of parking that they have that would trigger a new review.
And I'm just going to ask Bob to confirm that because we do have some people on the phone, so they can't necessarily see us nodding our heads.
Okay. Yeah, I looked at the site plan review. I looked at the square footage that the granite company wants to take. And there is sufficient parking at the building for the granite business. Okay. As you know, parking requirements are set by the square footage and the use of the space. Retail space, I believe, is 4 per 1,000 square feet. They get 3,000 square feet, a little bit more than that. So they need 13 spaces, and they have that. They're also currently permitted to rebuild the handicapped accessibility ramps, and part of that is identifying the parking spots for accessibility that will service those ramps. So that is currently in the works. In terms of an upgrade, because the ramp that they had previous to what they're putting in now was in pretty tough shape. I know that this is kind of an off the subject just a little bit, but I want to make it clear. Somebody had asked the question whether or not the columns in the front of the building are structural and if they serve any purpose in holding up the roof. The structural engineer who was on record for some of the other projects which are permitted inside the building has looked at those, and he has determined that the poles out front of the building are decorative in nature. The roof structure itself is a truss system with a built-in overhang over the sidewalks. So when people drive by and they notice that the columns are down, there's no reason to fear. That building was designed to not necessitate those poles. I just thought I'd clear that up. I know that question was floating out there.
Thank you, Bob.
You're welcome.
Okay. Any other questions from the board members at this time? Okay. All right. We did get a letter, and I know that the gentleman is in the audience at 1 Buck Hill Road, Michael Creamer, and he did pose 6 different either questions or requests for confirmation. And I just want to run through them because some of them have been now addressed, so I think that we can put them to rest. That he's should this special permit be granted, would the applicant agree to a provision where the granite cutting would be performed only with the doors closed in the bay? And that's for the text areas.
Yeah, sure. We have talked about this last week and that's
Okay.
totally fine with us.
Okay,
And,
all right, that's fine, okay. We have confirmed that there are no floor drains in question, so that has been resolved. That's number 3. Number 4, that there be a provision that the granite slabs are only stored inside. I think we already, I think the applicant agreed to that last week as well. Fred just confirmed that the spill remediation is based on MSDS.
Fran,
Yes?
you may want to ask the applicant to clarify that, because while we were on site yesterday, they did ask if there was a possibility for slabs to be stored outside at the
Okay.
rear of the building. And I believe the Groundwater Advisory Committee memo that you got indicated that there be no outside storage of hazardous material. Granite
Okay.
not being hazardous, I don't believe there'd be an objection on our end, but you
Okay.
may want to clarify that with the applicant as to whether or not what their intention would be.
Okay, thank you. Okay, so is it your intent to store granite slabs on the rear side of the building? The possibility?
Well, yes, and our hope is in the future, you know, like everybody else, that our business grow in a way that we can have some a little bit more, but not too much, because again, it's just gonna be me and my husband and a few more people. We are a small company. We know what we don't want to go crazy on this. And then eventually we may have something outside, but not anything that it's gonna be, for one, in the front of the building, because we need that space for the customers to park and everything else.
Okay.
But it's gonna be in the back. But again, it's not a crazy amount of anything. And it's, if that happens, it's gonna be just granite, which it's not hazardous whatsoever.
Okay, all right. One of the other points that the abutter brought up was about a sound study. And just ask Bob, I know that you mentioned the last time that you can't measure something that doesn't exist yet. So if you could just give us your insight or your thoughts on the merits of a sound study or not.
I don't know if a sound study is required by like a third-party engineer. There are sufficient guidelines in our own zoning for noise. One of the things that I alluded to is that I can go up and take a baseline almost any time, but it's the activity of the granite company, you know, the cutting or grinding or polishing of the granite is what is going to be measured against an ambient light, an ambient sound source. Keep in mind that when you do a noise study, vehicular traffic is specifically excluded from that. Okay, so what we would be looking at is essentially the noise of working with the granite. Okay, the applicant or the recommendation of the request has been made about doing everything indoors with the doors closed. That we won't be able to measure until they're actually up and running. But even with that, there are remediation factors you can use. What I can do is do a baseline at the beginning, almost any time now, and keep those numbers on file so that we have a baseline of what it is during, quote, the quiet time. And we can take it from there.
All right, thank you. Okay.
Excuse me, if you don't
yes.
mind just adding very quickly, after last week meeting, I was very curious about this question as well. And I ordered one of these simple things on Amazon about the sound meter thing. And I'm telling you, my husband, he was measuring the sound of a machine. And then I measure my little 5 months Yorkie, and her barking is louder than the machine, I swear. So just so you guys know.
Thank you very much.
You're welcome.
Okay. If no one else has questions, I do want to just ask, I think we did already ask this, and I apologize if it's already in the record.
I do have a.
Oh, okay, Leslie, go ahead, you first.
So in reference to the granite being stored outside, I mean, granite by itself is not a hazardous material, but a huge slab certainly can be dangerous. Could that be considered an attractive nuisance, or is there some way that it would need to be stored so that a piece couldn't accidentally fall on somebody? Or
is that a Bob question?
I'll take a crack at that one. Usually granite is stored kind of vertically, but on an angle, so its weight is against something. The other thing is that the property itself has a fence virtually around the entire thing. Currently, there's a couple of pieces of fence that are missing over to the right-hand side of the building where it's near the street. But I've been told by the owners that fence is going back up because they did an electrical service upgrade, and that's where they ran the pipes underground. Attractive nuisance, possibly. Would it be in the landlord's and the tenant's best interest to make sure the gates are secured at night? Sure. I don't know if we would have a whole lot of authority with that, considering it's a multi-tenant property. So I would think that probably the property owner would have to take some responsibility on that, because there are other attractive nuisances in there. You know, the welder has steel piles. You know, there are vehicles in there, kids love to play on trucks. So I think when the building is up and running and everything is in good shape, I would recommend, you know, having a functioning gate.
Okay, thank you.
If I,
Thanks.
if I
Mark?
could, if I could help you with that.
Okay, sure. Attorney Norris?
Yes, I represent a lot of granite companies and I'm pretty familiar with the slabs and the way they're stored outside. I think if you go by a lot of granite places, you will see the slabs outside. And as Bob indicated, they're slab, they are stored at an angle. It'd be very difficult for any child to move those. Those slabs are very heavy and they require a machine in order to move them.
Thank you. Mark,
Thanks.
you had a question?
Yeah. Bob, are you recommending that they actually put the bollards in front of the garage doors, or do you think just a prohibition that you can't pull vehicles into the facility is enough?
The plumbing code calls for a physical barrier. So just the prohibition on paper, I don't think would satisfy the requirement. So some sort of a bollard system would have to be installed. They would have to be close enough so that a registered vehicle could not be driven in. So forklifts are okay. You know, if it was a landscaper, the mowing machines would be okay. But, you know, things like cars, pickup trucks, large vehicles, those are the things you want to prevent from being inside the garage without a floor drain. So the short answer to your question is yes, they're going to need a physical barrier.
Okay.
Thank you. Okay. All right. If the board is willing, I'd like to open it up. And I apologize, I'm going to ask Mr. Creamer to come in first because hopefully I didn't butcher your letter. But so I have just added you. If there was something that I misstated or you wanted to add to the letter, if you would like to at this time. And state your address again for the record, please.
Sure. My name is Michael Creamer and I live at 1 Buck Hill Road here in Northborough. Appreciate all the answers, from the board, and just to Mr. Federico, just with regards to the sound study, thanks. I think that was the key for me, is to get the initial results before anything went in. So I would appreciate it if you could not only take some measurements there at the location, but also maybe throughout the neighborhood, in those public areas throughout the neighborhood. Thank you very much.
Yes, I will. Just to jump in real quick,
Sure.
My plan is to take, select 4 or 5 sites from where to draw the tests. I'll obviously be on the main road, but knowing that, there's sensitivities up in the Buck Hill area, I will be doing the test from up there as well.
Okay, thank you, Bob. All right, Mr. Creamer, anything in addition to this 6 points in the letter?
Just appreciative of the applicant too, to hear how the sound is going to be, but unless we measure, we have no idea how it was to begin with. So good to hear how their testing has gone. So thank you very much.
All right, thank you very much. Okay, so now I'm going to go back to Ms. Kraus because you had your hand up. Oh, yes, you had your hand up first. Unmute yourself, state your address and your questions to the board, please.
Okay, Joanne Kraus, 10 Buck Hill Road. I have a couple questions. My first one is, I just wanted to double check the site plan that you're voting on tonight is the one from September 4th and not the one that we saw last week, right?
I don't want to jump to that, but I believe the answer is yes. Paul, you have it up. Do you have the date on it?
I think the one that we got at the last meeting was dated September 4th. So part of the issue, Madam Chair, if I may, last week was that, this case was filed, whatever it was, March, April, May, sometime when COVID first hit. Groundwater met, they went over the original site plans, and then a new site plan came up, and groundwater had not met, and no one had actually reviewed it. Not to mention the fact that, this is mostly a indoors type of business that is looking to get a special permit approved, where the new site plan not only encompasses some of the 329, but also a lot of the stuff next door. And so, I think it was just it seemed like it was a very big change from what we saw or what was initially filed versus what was presented last week.
Okay. All right.
So Fran,
Yeah, sure, Kathy.
Fran, if I could, the site plan that I think either Fred or Bill referenced tonight, excuse me, Bob referenced tonight, that came in with the application is actually dated April 24th, 2020. And that was prepared by Jarvis Survey. And that was, like I said, that was part of the original application. So that's the site plan that would be referenced in the decision.
Okay, thank you. And then the other question is, this granite company, it's gonna go on 4,000 square feet. Now, if they wanted to expand that business and make it bigger, would they have to come back before the board to get for an expansion, or would that just be able to be granted, you know, by somebody who works for the town?
I'll take a stab at that.
Okay.
I see Bob struggling or thinking. I would say if the granite company, Newbridge Granite, wanted to expand to the point that they were increasing the amount of chemicals that they would have beyond what is allowed if the board were to grant their approval of the 45-gallon maximum, then they would have to come back. If they were not expanding, I believe that the building is appropriate for the use as it is without the chemicals, and that would not require a return to either of the boards for approval, and it could be done in-house. And Bob can correct me if I'm overstating.
No, you actually, you said it quite well. One thing to remember is that the granite company coming in, there are two things going on. One is a retail establishment, which is allowed by right and does not have to go to any planning or zoning or anything like that. If by chance their business takes off and they need additional showroom space or additional office space, or if they want to expand and put in some sort of a lounge for their employees or whatever, that is allowed without having to go to any board. Because it's in a groundwater area, and if they're going to increase the amount of chemicals that they're using, or if they're going to change substantially the type of chemicals they're using, then yes, I do think of a revisit with the groundwater advisory committee would be appropriate.
Thank you, Bob.
Thank you. One more question. Now, so if this tenant decides they don't want to stay and they you know, they move out, does this permit allow somebody new to come in and take up shop, or do they have to, or is this permit tied to the actual tenant, Granite, the actual Granite company, Newbridge?
My opinion would be that another granite company could go in there, provided they did not need to store more than the 45 gallons worth of chemicals that's allowed if the board chooses to grant the permit.
Can we condition it that it only stay with this one tenant and that it's not transferable to another company coming in?
I'm not sure that's legal, but I would defer to the building inspector.
And I would probably defer to town council on that. Typically, once a special permit is granted, I honestly don't know if you can condition it to somebody's tenancy within a building, or if you can condition it to somebody's ownership of a property. That's a question that I think town council would have to weigh in on.
If a new tenant were to go in there and they're proposing a use that's allowed by right, I would think it'd be difficult to condition otherwise.
Right, so if a different showroom of, you know, a shoe store wanted to go in there, they could go in there. That's not an issue, because it's a business that's allowed by right. There's no chemicals, so the groundwater isn't triggered.
Right.
Okay.
If it was another granite company that needed to store 150 gallons of impregnator or other chemicals, then that would trigger an amendment to the special permit by the Groundwater Advisory Committee and the ZBA.
Thank you. Okay, Ms. Cross, I have other people that
Okay,
want to ask
all right.
questions. Are you okay?
Yep,
if I
I'm
move
good.
along?
Thank you very much.
Thank you. All right, I have Eric Hansen. If you could state your address, please, for the record.
Sure. Eric Hansen, 6 Buck Hill Road. Hopefully you can hear me fine.
Yep, you can.
I just wanted to kind of go back to some things from last week. I'm going to stay away from the allowed by right, which I believe is sort of a contention for when you talk about the industrial use of fabrication. But I want to talk about the granite inside storage. Last week, they specifically said that they had no intention to store material outside. And this is the part that sort of builds angst in the neighborhood, in that these businesses slowly start to creep and change the way they operate. Last week, they said no storage outside. Now they're saying, well, we're hoping that, maybe just a little bit outside. And as we grow, we may have to expand that a little bit. And last week, they said that, the forklifts would only be about 15 minutes to unload the truck or whatever it was. And that was it, because everything was inside. It wouldn't be a problem. Now, all of a sudden, it's, well, we might have storage of granite outside. That's going to now require more forklifts to have to move things from outside to inside. That could be more during the day. So that's one point I have, is like, I'd like to know if there are any, or if we could put some conditions on that, and not just leave it open-ended for them to be like, well, now you can start to store some outside. And then when they did say we might store some outside, did you notice that they didn't really give a number? They just kind of left it, well, some, but as we grow, we hope to get bigger. Well, when you live in our neighborhood so close to those businesses, my concern is, well, some is 4 or 5, or is some 50 or 60? And then as you grow, is that going to be 100 slabs outside? You say, it's only the wife and the husband working there with a couple workers, but as you grow, you're implying you'll get more employees. So that's a concern to me. Also, the parking for that, will the vehicles for this business be specifically on the current parking spots, or is it contingent upon the site plan? Because one of the things that was mentioned, I think by Mr. Litchfield, was that, trucks are not allowed on the granite parking area. Which would imply that they need to pave that area, which would be now conditional upon the site plan. And my concern was that a letter was sent by Mr. Federico about not parking on the gravel, but I just walked outside, and this is where I'm not sure about 333. Is that the site with the gravel you're talking about? Because right now there's probably 10 trucks parked on the gravel out there. So who's enforcing that? If their letter was sent, they're clearly ignoring that. So those are just a couple of concerns I have, where, again, I feel like businesses sometimes run with the leniency, and I would like very specific conditions put on the business. Thank you for your time. I appreciate it.
Thank you very much, Mr. Hanson. Okay, I have a person, the last name is Leonard. If you could state your name and your address, please, and unmute yourself. Thank you.
Hi, this is Chihei Leonard. I'm at 5 Buck Hill Road. So actually, Mr. Hanson did a good job about bringing up a lot of these points, as did Joanne. I just wanted to sort of reiterate that. I think because the special permit that the tenant is requesting is for fabrication, that you did mention that you weren't sure that you would not be able to tie it to the tenant, as in, like if it was sort of sent to, like if, another granite company, decided to go in there in the future. So that might be that would be something that would be a question for me to ask, I guess, council, because, as we're giving the tenant a special permit to do this type of business, I guess the concern is that now we're grandfathering in like future businesses that still are basically going to be using some of the business, at least for an industrial or fabrication type of use, and not just business use.
Okay, Ms. Leonard, I do believe that the engineer, Fred Litchfield, did state specifically that if another granite company came in at same size and exact same business, it would not necessarily trigger another process, but anything different would possibly due to the groundwater. Is that correct, Fred?
Anything that required additional chemical storage on site. If your decision is to limit, if it approves the site and limits the amount of chemical storage to the 45 gallons that the groundwater committee recommended, anything beyond that would require a new or amended permit.
Thank you, Fred. And Ms. Leonard, if you have some new information, that would be appreciated, because we do have several people, and I apologize to trying to rush you, but we do have 5 other hearings to hear tonight before 9:30.
I understand. That was actually my main question, to be honest with you.
Okay.
Thanks.
All right, thank you very much. I appreciate that. Okay. Board members, any additional questions for the applicant, their attorney, or each other? Okay, town staff?
I'm sorry,
Paul,
Madam,
sure.
yeah, just one. Do they need to store granite slabs outside?
Say again, please.
If we need
Do you need to store granite slabs outside?
Well, we don't need to, because the last week when they asked me about slab, they asked me if I was putting like a 300 slabs outside. I'm not gonna have 300 slabs outside. I can work with the slabs inside. If I could have some slabs outside, that would be help. But you know, if they said only inside, you know, I have to work only inside.
The only reason why we are bringing these questions, and I appreciate the neighbors' questions and inputs. Me as a neighbor, I would be the same way, believe me. The only reason we're saying this is that eventually we're gonna have a few slabs outside, and I don't wanna do anything that is not correct or legal or whatever you wanna call. So if I have in a few years or months, whatever we wanna call, some of you guys coming and, you know, looking at it or, you know, see this is allowed or not allowed. That's what we're trying to do. We're trying to do everything that is clear for all of us.
At your current location, how many slabs do you have outside?
Currently, we don't have a location. This is going to be our first one.
Oh, okay.
But I mean, again, I can tell you right now, for our first year, even as like luckily we start tomorrow, let's say for our first year, that's going to be nothing outside. But I don't want to, you know, get to a point where I need to put 10, 15, 20 outside. And then here I am stuck because I didn't mention that. I'm trying to do what is right for all of us.
Okay, thank you.
You're welcome.
Okay. All right. Board
One
members?
question.
Yep, Mark.
Mark?
Mhm.
Bob, in your opinion, would storage outside be an accessory to the retail operation, or would it be an accessory to the industrial operation? I mean, I can kind of see the slab storage as part of their retail.
It's part of the retail. That's how I would see it. I would have to go into the fine print of the zoning to see what type of outside storage is allowed. I do know that outside displays are allowed during business hours. Like if something was portable, they wanted to put a small sample board out, that is okay. But in terms of storage, I'd have to look into it. The other thing is they're proposing, if they're going to have outside storage, it's going to be in the back of the building where it's typically out of the view of the general public. So I'm going to have to, I'll look into it kind of, well, right now, give me a couple of minutes.
Yeah.
Thank you.
Well, I'll look at it.
Okay,
All
thank
right.
you.
Fred, you had, go ahead, Fred.
I'd offer suggestion if the board was amenable to it. If the applicant feels they're going to need some storage, I think the abutters are correct in asking for some quantity of space and perhaps a fenced area within the larger fenced area that the building inspector already talked about would be appropriate. You know, you could limit it to 200 square feet or 300 square feet or whatever is appropriate, provided it didn't take away from any of the parking that is required for the overall site.
Sounds perfect.
Thank you, Fred. Brad, I'm sorry, you had a question or comment?
Yeah, question for the applicants. One of Mr. Litchfield's comments came up that you do have the proper amount of parking based on the square footage. Based on our decision tonight, would you be amenable to us working with the original site plan versus the site plan that was given to us last week with the additional parking? Does that sound like something that you'd be able to work with?
I'm sorry, is that question for us?
Yes.
Okay, so just to clarify that, the first site plan you have, it was actually provided by me and my husband, by my company, that we pay an engineer to do without knowing that, for one, we're gonna have this pandemic thing going on, and also that the whole building will have to have this whole construction. So we paid this gentleman to do. Now we have the second site plan. So I honestly don't know how much they match. That's why I have my lawyer working with the landlord and you guys as well So I cannot tell you right away, right now, you know, whether I agree or not agree, because I really don't understand the second plan because we just got them like last week or so. But again, once we agree with something, I'm gonna do everything that is under the law to do the right thing, whatever it is.
If I could answer your question.
Sure.
I think the original site plan that was submitted, we submitted, and then there was some question about the board wanting a complete site plan, which is what was then subsequently submitted. But I think the original site plan properly shows the building, it shows the square footage, and then the parking would have to be in compliance with the zoning bylaws. So that would, the original site plan, I think, would be fine.
Okay.
Okay.
All right.
Thank you,
Okay.
everyone.
You are
Thank
my
you.
voice.
All right,
Thank you.
Fred, you had something?
I would go back to my original comment that the building had sufficient parking when it was originally permitted. I think because it's unclear about the whole site, that if you were to approve, you would require 13 spaces be dedicated for this business and be signed appropriately with signs that say parking for new bridge granite only. And then whether they're in front of the building or on the side of the building, doesn't matter. But if there are 13 spaces out of the total that's on the site be dedicated for this business, you're ensured that there's adequate parking for this business under the bylaw.
Thank you again, Fred.
Okay.
All right. All right, does anyone else have any additional questions or concerns? Ms. Kraus, I see that your hand is up. I'm not sure. I thought I put it down, so I'm just going to check real quick. Did you have
Thank
your?
you. I have one more, I have one more thing to say.
Okay.
Okay, so we do have an attorney online with us here, and he said that special permits run with the land, not the applicant, unless the ZBA conditions it to the applicant only. The ZBA can condition it to the applicant if it wishes to.
Okay, and who's the attorney that's on the line, Ms. Kraus?
Mark Lanza.
Okay, thank you very much. Okay. If no one has anything else, does anyone interested in closing?
I
the-
move that we close the hearing.
Okay, that was Mark. Is there a second?
Second.
Okay, I'm going to give that one to Dick. So Mark's, that's a motion and a second. All those in favor on roll call, Mark,
Aye.
Dick,
Aye.
Brad,
Aye.
Paul,
Aye.
Fran, aye. Thank you very much. Hopefully we'll get to this at the end of our meeting tonight. The next application is to consider the petition of 8688 Main Street LLC for a variance special permit with site plan approval, special permit groundwater protection overlay district to construct buildings for 2 contractors' yards at 50 Southwest Cutoff, map 82, parcel 1, map 95, parcels 11 and 12, located in the Business West and Residential Zone C zoning district. And I am going to ask Kathy to tell me who it is that we are bringing in. Please, and thank you.
All right, I think that,
Tim Shea.
yeah, Tim Shea is on. I think
Okay.
Nick, actually, I'm not, yep, Nick Muskoff
1 second.
is on, and also James Tatro,
Okay, 1 second.
who is the engineer,
James.
James is on the phone, and the last 3 numbers are 099.
Hey, James. Okay, so I have a Tim, a Nick, and a James. Okay, and if I,
Now-
so James, yep, there you go. All right, I
Hello?
have everyone. Okay, one moment, Kathy.
No, I want to ask the applicant, do you have your site plan, or do you need me to try to put it up like we did with design review?
We would like you to put it up, Kathy.
That's a big ask. Okay. I think I can do this. None of you see anything, correct?
Not yet.
Okay, let me try this again. Do you see that?
You do.
Okay, so James, that's the revised, I believe that's the revised landscape plan. Is that what you want to start with, or what would you like to start with?
We can go with that. That's fine.
Okay, just let me know if and when you want to switch.
Oh,
sure.
Where'd it go? I don't have it anymore.
Oh, I see it.
Oh, there it is. Got it.
So, so to the chair and the other board members, thank you for your time here. The application before you is a special permit for to allow the use of the construction, of 2 buildings on this property. And the property at 50 Southwest Cutoff, it's directly opposite the Cromaro Tarpaulin, if that gives you some help. And also it's directly opposite the more southerly intersection of King Street with Route 20. And it was formerly the Del Greco Masonry Supply. If you drive by there right now, you will see a mostly paved site with a small office up front, a larger structure which was both manufacture and storage kind of in the middle of the property, and a little small sort of a shed towards the south end of the property. And that was categorized by the building inspector as a contractor's yard use, and the proposed use of the site by the applicant also as a contractor's yard use. And this property is mostly in the Business West district, the upper 2/3 of it. The most southerly third is in Residence C. We're making sure that the buildings would be within Business West or just enough over the line that is permissible under the zoning bylaw. Right now, the site, besides being largely paved and having those buildings, has no particular improvements to it. There's no drainage system on site right now. I'm not sure what the septic system is. And there are 2 driveway accesses onto Route 20, neither of which is in a particularly good spot, frankly. So what we're proposing to do with the construction of these 2 buildings is to construct a new access at the south end of the frontage, which is closest to the high point of Southwest Cutoff of Route 20 and gets the best site distance. I just would note as a parenthetically that we filed a highway access permit application with Mass DOT, and actually the only, that's Kathy's showing where the proposed access is. The only comment we got back, the most significant in Chris Chambers' own words, is that our curb rounding at Route 20 right there just edged in front of the Del Greco property to the south of it, and wants us to change that. But he had no other significant request for change. So these 2 buildings, 9,600 square feet, the one that faces Route 20, and 7,000 square feet, the one turned 90 degrees to it, would both be for contractors' yard uses. The applicants, who include the folks who make up Stone Ridge Development, have a similar site, actually 2, in Sterling, that are used as, you have electricians, you have plumbers, those sorts of businesses who use these spaces as have some small office to it, but they use it for storing gear and material, and they may have a truck parked out back, which the employees come in and then they drive the plumber's truck with all the tools, etc., out to a job site. That's the kind of uses that you see here, and I don't think it's not so incongruous with this area. You've got commercial real estate immediately to the north. You've got the tarpaulin business across the street. You have some other automotive uses just to the north associated with King Street. It's not, and again, as I say, the building inspector has categorized this as effectively a grandfathered continuation of contractor's yard use of this property. The folks at Stone Ridge, who again make up part of 86 to 88 Main LLC, the applicant, I think have built themselves an excellent reputation for keeping their sites neat and clean and well kept up in general. We went to the design review committee, and they wanted us to do more landscaping planting as a sort of a buffer off of Route 20. So the plan that's in front of you, essentially for most of that frontage, proposes actually 3 different layers of plantings to give some visual buffer of these buildings, I should say, from the traffic going by. The proposed use is actually very similar for traffic generation from the masonry supply use when that was active. If you go to the ITE charts, the numbers actually are a little lower for this than for the building supplies use of the Del Greco masonry supply. I'd point out that we've done soil testing for a septic system on the west side of the property. Behind the larger building, you see some hatched narrow rectangles. Those are intended septic system leaching trenches. We already did official testing for that. We did testing also, you see, at the north of the property, near where the property to the north labeled 38 Southwest Cutoff Realty Trust. You see a sort of a, maybe it looks like hatched at this scale, but that's a proposed infiltration structure. We did tests there. And as I say, there's no drainage system at all on site now. What would be the case in the future is that a total of 11 catch basins would capture almost all the runoff on site. We'd have no connection to Route 20. Everything would go through a stormwater filter unit, then to this infiltration structure, and it would be at its size such that until you get to the 10-year storm, you do not get outflow from it. So I guess the one other thing I would note is after some discussion with the water department, we propose, if you look on the note in the street, right in the middle of that southwest cutoff label, you see is where a proposed water line connection to be able to provide a fire service connection to the larger building. Right now, there's only a small residential water service size connection to the main on the opposite side of Route 20. We would be installing a new much larger water connection and putting a hydrant in on the property. So I think I can safely say that there's no lack of infrastructure to deal with this. I don't think it's again, especially as a continuation of the previous use, but given what's around it, I don't think it's an incongruous use in this location. And I think if the board chose not to grant the special permit to allow 2 buildings, the applicant, one response that he might have to that would be to simply make one much larger building. And frankly, again, a lot of the feedback from the design review committee was that they didn't want this to be, especially visible, and it would be more so if it was made that way. But I don't think this creates any unusual. I should note also one last thing. We did check the site distance at this point. The reason we again have the proposed entrance at the south end of the frontage is because that was the best site distance, and you can see from there to a car approximately in front of Lexington Road. You can see adequately that side and also to the north from folks coming up the hill. And so there's not any particular hazard entailed by the proposed change and redevelopment of the property. In fact, I think it's much better than those existing driveway entrances now. I've parked there a few times myself, and I was not feeling so confident as I was pulling out each time. So this would be an improvement on the property. Again, the applicant includes the folks, Tim Shea and Nick Muskoff on the line, who have of Stone Ridge Development, who have done a terrific job on all of their properties. And I think, again, it's not an incongruous thing. And one last point is that I know that there had been a lot of interest in town for different properties as contractors' yard sites. And some of those other properties that were considered were in the groundwater protection district, and thus had significant limitations for that reason. This property is not in the groundwater protection district, not overly, 1, 2, or 3. And for that reason, it's actually a pretty appropriate location for such a use as this. And being on Route 20, Southwest Cutoff, I think it's also a pretty appropriate location for this. But I'll try and answer any questions you have. I'm sure Tim Shea and Nick will also chime in and try and answer whatever questions the board may pose.
Thank you very much. Okay, board members. Who would like to start? Okay, all right.
Madam Chair,
Who's
Ms.
that?
Paul.
Oh, thank you,
Oh.
Paul.
Can you just confirm what is the current total impervious coverage as exists today, and then what is the new calculation number?
I don't have the exact numbers with me. It is a slight increase. I can tell you that it is an increase. But the way the drainage works is that, except for what goes down to Southwest Cutoff right at the new driveway, we're literally cutting off, appropriately enough, the drainage to Southwest Cutoff, and we make the drainage work to the other abutters by forcing it through that infiltration structure, which, as I say, despite there being an increase in impervious, won't let out any, won't have any pipe discharge until you get to the 10-year storm.
Okay. So you said that you went before the design review committee made some recommendations. Have they seen this more recent proposal with the shrubbery?
We submitted it. We sent it into Kathy to pass along to Dave Veron, who is especially the landscape-minded guy on the design review committee meeting. We have not had another hearing with them,
Okay.
but again, what you see on screen was in direct response to their comments at our hearing with them.
Okay. All right.
Fran, the next meeting of the design review committee is October 7th.
Oh,
And this
okay.
at 6 o'clock, and this applicant is who's on the agenda.
Oh, excellent. And also on with the planning board for technical review.
Yes,
the day
and on
before.
yes, on the planning board has asked the applicant to come in to their October 6th meeting to review the site plan.
All right, thank you. All right, Fred, can you talk a little bit about have you seen the plan as far as the septic? Because we don't have anything in writing from you. Just wondering if you have reviewed it. You're muted. There you go. Thank you.
I have seen the plan.
Mhm.
I have not completed my review. It was my understanding that the design review committee continued. My expectation was that the ZBA would continue as well, and I get a chance to finish my review for your next meeting. I will concur with a lot of the statements that Mr. Tatro said. The site distance at the location of the proposed driveway is a significant improvement. The property is not within a groundwater area. Any drainage that's added to this site would be an improvement. And the fact that they're recharging quite a bit of it bodes well. It is a clean site. This is in my opinion, this is a very appropriate location for this kind of a use. And I expect that when I do my review, the drainage will be adequate. I will have, I'm sure, some comments. I do need to discuss with the DPW what they had indicated for comments on the water line. I wasn't aware that they'd already shared some comments with the applicant. So I would defer my final comments to you for your next meeting.
Excellent. Okay, so board members, questions at this time? It sounds like we may be requesting a continuance, but we should really get all the questions on the table so that the applicant has an opportunity to have them all answered.
Yeah, Madam Chair, I have a question. Yeah, so I really appreciate the fact that we're down to one entrance exit on Route 20. I mean, we've seen a handful of applications in this area, and the fewer intersections, the better, in my opinion. So I really appreciate that. I really appreciate the fact with all the landscaping, the berms in the front. My only question / comment is, I know this abuts residential, and just by looking at the names, they're got to be some way related to the original owners of this property. But is there any question about adding additional landscaping to abut the proposal versus residential? I'm just thinking long term, just trying to separate the two, because I know this is starting to come up a lot, not just this application, but residential abutting industrial, residential abutting commercial, and just try to appease all parties. So is that something you guys are thinking of? I only see right now just 7 trees, but I mean, doubling it and just really cutting off the loop at the bottom. Sorry, Kathy, all the way at the bottom.
If I may, actually, there are the trees.
Yeah.
There are the 7 white firs. There are also 12 rhododendrons and 4 northern bayberries at sort of the west end of that. So we're trying to. We actually did double up in response. We initially just had the 7AC, AB's concolor, the white firs there, and in response to the commentary at the design review committee meeting, we added the 12 rhododendrons to beef up that buffer.
Okay, thank you. Yeah, that just comes up, and yeah, every little bit helps as far as the landscaping. So thank you.
I think, Mark, you had your hand up?
Yeah, I was just wondering, is there any limit to the hours of operations when we can expect contractors to come in and out of this?
Okay.
I was going to defer to Tim on that, or
At
this time, we don't know who's going to be leasing the space, and we don't know if what if we lease space to an ambulance company? We have no idea who our tenants are going to be. They might be people plowing for the town of Northborough. I really think that that we should allow them to operate, and it's going to be coming and going. I'd hate to limit that. And as you know, even the town of Northborough from time to time hires excavation companies that do work, emergency work. And what are we going to do? Tell the people that live near the flooded zone that we can't do the work till 8 in the morning when we can load up the truck? I just think it's very limiting.
All right, thank you.
As a follow-up, what is the, you have this type of operation in other locales. What are the hours of operations in those communities?
They in Sterling, they asked us to be reasonable with our abutting neighbors, and we have said we would be, and we've explained that to our 7 tenants.
Okay, and they leave reasonable as an interpretation of, I guess, if nobody complains, it's reasonable?
Well, if like an insulation company, for example, that leases from us, they probably work, 7 to 5, 7 a.m. to 5 p.m. Most people work in construction, for example, 7 to 4, something like that. And every now and then there's an emergency. And so the job might take a little longer. But I mean, we're anticipating service people, as James said, a plumber, an electrician, people that you would allow to do work at your house. You just would rather they didn't park the van in the driveway next door to your home. Instead, they could park it in this facility.
All right, thank you. Other members of the board with questions or concerns?
Yeah, Madam Chair.
Yes, Brad?
Following up on that, and that was one of my questions, so thank you, Mark. What are the so obviously I'm digging through the bylaw book here. Is it 7 a.m.? So for contractors or construction, is it 7 a.m. to?
Yep. They can't start vehicles make sound before 7 a.m. and not at all on Sundays for commercial construction and or, well, if Bob's there, he can jump in, but I know what you're referring to.
To 11? Yeah, something like that. I don't know, but
Yeah, I think so.
I mean, is that
Yeah.
something that we could? I mean, I think that's fairly generous. I'm not saying 9 to 5 or 9 to 3 or anything like that, but I mean 7 a.m. I think that's fairly reasonable for something like this.
What do we do about the snow and kids going to school? Do you have any ideas?
All right, well, we're just,
Well, now we're all remote, so you know what? There's no such thing as a snow day anymore.
there you go. That's pretty disappointing, I'm sure.
All
All right, so
We'll see.
Bob? I'm
Madam
sorry,
Chair, may I
Bob?
chime in?
Yes, absolutely.
703020, it's section E, page 7-12. Construction equipment may be operated by a paid contractor. Okay, so if somebody's working on your house or if somebody's working to build these buildings, they can't start until 7 a.m. Okay,
Okay,
and they have to finish at 7 p.m. That's for a paid contractor working on a property. Okay, if you're a tenant, I don't think this particular provision applies.
okay.
Okay,
Okay. So if we had concerns, it would be conditions placed on the special permit should it be granted. Okay, all right, Mark?
Madam Chair, I
Yes.
might point out that I believe across the street is the tow truck company. And they must roll out of there at all hours of the day because people get into accidents at all hours of the day.
Sure, that's true. They're not 16,600 square feet of that type of activity, but that is true. So, okay. Other board members or staff?
I've got a question.
Oh, sure, Dick.
Will there be any outside storage of materials or is everything going to be confined to inside the building?
Again, we're not sure who our tenants are going to be. We have the garage doors in the back of the building, the back of the larger building. So if they have, say, a landscaper has patio blocks or something, he may store them behind the building, out of sight, or some other material on a paved area. But again, our intent is to have storage be especially behind the larger building. That's the plan.
Okay, how about dumpsters? Will they be behind the buildings and concealed?
You'll have to handle that one, James.
Yeah, the intention is that the dumpsters be behind the building. What you're would see in the front of each of these is just parking aisle, parking spaces, and entrance doors. As Tim was saying, on both buildings, but you would have garage doors in the back of the building, which on the 9,600 square feet is away from Southwest Cutoff, away from Route 20. On the smaller building to the north, it is the back of the building is towards the north, and which was why we, even before the design review committee's input, we were trying to make it a special point of doing buffering and vegetative wall, if you will, to block off that from view.
Okay, thank
Madam
you.
Chair, if I may,
Yes, Bob?
outside storage is an allowed accessory use by right for a contractor's yard. Typically, you'd want it in the rear of the building. They don't want it in any kind of a minimum setback, either on the front setback, sides or rear setback. But it is allowed by right as part of the definition of a contractor's yard.
Thank you, Bob, for that. Okay, so I have a question. Typically on these site plans, we would see locations of dumpsters to follow up on Dick Rand's point, as well as where snow removal would go for the site.
Sure, we can add those notations. The intention really is that, especially the area to the west of the 7,000 square foot building, be the particular point for plowing snow. But we're playing around with some ideas in regard to the dumpster locations, but we could add specific spots to satisfy you.
Okay, thank you. All right. Kathy?
Madam Chair, just
sure,
one
Paul.
just one last part. So currently, it's owned by Del Greco, and it's a contractor's yard with a small building, I think is what the proposal had, with a bunch of materials that are all around the yard, right? And this new plan is basically an entirely paved or almost entirely paved surface with two very large buildings on it. Is that's still considered a contractor's yard, even though it's, you know, there's no trucks, that doesn't look like there's any spaces for trucks, it's just two big, you know, commercial buildings? I guess that use is still the same? That's what,
Yes, it still fits the definition of a contractor's yard.
okay.
Okay.
That's all I had.
Thank you, Paul. All right, so I have two hands up in the audience. I can circle back to staff and the board if you have any additional questions, but it does sound like we're going to ask for a continuance on this from the applicant, but let's see what the questions are from the audience. And I'm going to start with Mr. Hanson. Again, if you could state your name and your address when I unmute you. Oh, actually, it's saying ask to unmute. Oh, now, there you go.
Yep, Eric Hansen, 6 Buck Hill Road. I just had a quick question again about the idea of allowed by right here on this as an industrial business going again into a business. This is sort of the same problem on the westerly end with 329, 333. Mr. Federico saying it's allowed by right. The contention again is that this is not the same kind of business. And based on many of the different powers test case law, this would not be deemed the same type of business. Has that been looked at all? Again, this is sort of this idea that the right is in perpetuity once it's been determined that it's an industrial site. And, you know, again, as you know, we're contesting that. So it seems like these businesses are just coming in. And if we're allowing this, is this another business that's going to face the same problem where if it's overturned, that this business also could sort of be in violation of what the law says for what's allowed in the Business West District? Thank you.
Thank you.
If I may, just quickly, I won't profess to be a lawyer, but the idea, you don't have an industrial use allowed in perpetuity if there's a disruption in the continuity of that use. If somebody came in and did something completely different in the site, a party after that person could not say, I want to go back to being a contractor yard. That wouldn't be allowed. I believe part of the issue here is that this is deemed a contractor's yard use now, and the proposed use is deemed a contractor's yard, and that is a continuation of a grandfathered use.
Okay, and Bob, you are the zoning enforcement officer who has made that determination. Is that correct?
That is correct.
Thank you. Kathy, do you have your hand up? There's a green arrow next to your name. That could be you sharing.
No, I do not. I think it's just this, the screen sharing.
Okay, all right. Okay, thank you. Okay, Ms. Kraus, I'm going to unmute you. Sorry.
First one is for Fred. so we have 13 drinking wells that abut this property, and I'm wondering if we could request a study to make sure that, all of this, this industrial company going in here, it could affect our drinking water. That's one of
Okay.
them.
Okay,
And
so
the
one
other
moment.
one,
All right, well, let's do one at a time. Fred, are there 13 drinking wells within abutting this property?
I can't confirm that. I don't know. The Board of Health keeps the records of the private property drinking wells. It's not something that I would have readily available to me tonight.
Okay, fabulous. Okay, all right, Ms. Kraus?
and I was wondering, will the contractors have, fertilizers or any other, hazardous materials stored on site? And would there be any chance of that seeping into the drinking water?
That's a good question.
If I may, just the idea of wanting to test what could be the effect on drinking water when there is no, even as Mr. Shea says, there is no particular use known at this point. So I don't think that makes sense actually, because you're going to test for everything, and that would be literally impossible. I appreciate the sentiment on behalf of Mrs. Kraus, but I think asking to test for everything, which is essentially what you would have to do, wouldn't make sense.
All right, so I guess the question then is to Bob, well, it's not in groundwater protection, so the reality is, I don't want to say the town's not concerned because it's not a groundwater protection area, but if residents abutted the property who had wells and felt that it would be compromised, what is their recourse? Are you aware, or is that something Ms. Kraus will have to investigate through the Department of Public Health?
It would probably be an answer best handled by the Board of Health or the health agent.
Okay.
Generally, if it's not a groundwater concern, and there's no flooding or no wetlands or any of that sort of protection, there would be a civil case between one neighbor and the other, to figure that out.
All right, thank you.
If I could just briefly, too, I want to just mention that if you look to the west side of this property, to the left side on the sheet on the screen, that property is JSB Times Square LLC. You have to go about 500 feet back from this property to the west, to the left on that sheet, to get to the lots on Buck Hill.
Oh, okay.
There's
Thank you.
nobody who's in a butter to this property who is on a well.
Okay, thank you. Okay. Any final questions or for tonight, questions that we want the applicant to have addressed for the continued hearing later in a few weeks? Okay. And Mr. Shea, are you amenable to the continuation to our October 27th meeting? Since you're going before design review as well as planning board on the 6th and 7th?
Yes, we'll see you then. Thank you very much.
Okay, so if I could hear a motion from someone on the board for continuance to our October 27th at 6 p.m. meeting?
I
Madam
move that
Chair,
we,
no,
go ahead.
sorry, you can go, Mark.
No, fire away.
Madam Chair, I make a motion to continue the petition of 86-88 Main Street LLC for variance special permit with site plan approval to construct buildings for 2 contractors' yards at 50 Southwest Cutoff, map 82, parcel 1, map 95, parcels 11 and 12, located in the Business West and Residential C zoning districts to October, what was the date again?
27th.
27th at 6 p.m.
Okay, there's
Second.
a motion and a Brad second.
Yes.
Okay, a roll call vote. Paul?
Yes, aye.
Brad?
Aye.
Mark?
Aye.
Dick?
Aye.
Fran? Aye. Okay, so it's continued to our October 27th meeting. Mr. Shea and company, thank you very much.
Thank
Thank you
you.
for your time.
So we're moving on to consider the petition of Geodeep Pellerin for a variance special permit with site plan approval, special permit groundwater protection overlay district to construct a carport at 17 Mayflower Road, map 95, parcel 89, located in the residential C zoning district and groundwater protection overlay district area 3. And let's hope that the Pellerins are still here with us tonight. Let me see if I can, hopefully they are here by name. GOD, I think is this one of the applicants that I just unmuted?
Yes, Jody.
Okay.
I like
Oh,
that
Jody,
that you put into my name.
GEODI?
Yeah.
Okay, and Jody, is there someone else besides yourself that's here? Or are you
No,
on the same
just me.
call? Okay, all right, well, fabulous. Well, if you can just state your name and your address for the record and then tell us what you're proposing.
Okay, Jody Pellerin, 17 Mayflower Road in Northborough. And I would like to get a carport put over part of my driveway.
Okay, and is there currently a garage on your property?
No,
Okay, and it's a permanent structure?
yes, according to, I checked with Bob before we went forward with it, and he said, yes, it was.
Okay, and you need a variance because you're encroaching on the setbacks?
Yes.
Okay, and do you know how many feet into the setback you are?
I think it was 3. It was on the paperwork. I didn't keep a copy with myself. I think it's like 2 or 3 feet, something like that.
Okay, all right, okay.
Fran, if I just
Sure.
could, to help out Jody, the issue here is it's very similar to what you had at a couple meetings ago with One Rustic Drive, where this is a corner lot, and you're gonna see that again at your next meeting too. But it's a corner lot on, and so therefore she has 2 front yards and 2 side or rear side.
No, I'm not a corner lot.
Oh, okay. Sorry, Jody. That's
that must be for
one
next
of the
month.
other ones tonight. I'm sorry.
That's okay.
So on this particular one, but it still involves a setback.
Yes, it is the setback, yes.
The side yard setback actually on for the residential zone is 15 feet, and what Jody needs is a variance granting her about 4 feet of relief.
4 feet, okay.
All right, so there's 11 feet between the proposed carport and the property line.
Yes.
Okay, all right, but there's also, because it's in the groundwater district, we have to be concerned with the impervious cover, and that's what the calculation sheet is?
Yeah, it doesn't increase the impervious cover. It's going to go over the driveway, existing driveway.
Okay, all right, well, thank you very much. Does any of the board members have any questions for the applicant? Brad?
Yeah, Madam Chair, quick question. So looking at the plans, so it looks like the driveway is already pre-existing non-conforming, and that may be a question for Bob, and the applicant is just looking for a carport just to store her car. So it's really no additional encroachment on the side setback. Is that accurate?
It's
As Bob's looking at that, there's the driveway itself is not a pre-existing non-conforming.
Okay.
But I mean, it does exist, but
Yeah.
the driveways don't have that status.
Okay.
But as you pointed out, Brad, and as Jody said, what she's proposing is for it to be over the exact same location, a portion of her driveway.
Okay.
So it's not, there's not more impervious cover happening. And also, which is where I think Bob was going to go, was with residential development. Bob and Fred handle the impervious coverage. If there's an issue as far as, they'll have roof drains and things like that require as part of the building permit. But it's not an issue here.
Okay. Yeah, I mean, kind of what I was getting at. Thank you, Kathy. But kind of, what I was getting at is it's not like they're just throwing something up there. It's all brand new. Like the driveway has been there. They're not.
They're covering it.
covering it, essentially. Yeah, thank you, Fran. Yeah.
Yeah, when,
Okay.
when it comes to accessory structures, driveways typically are not classified as an accessory structure. Any kind of a garage, carport, cabana, pool house, that sort of thing would be considered an accessory structure.
Okay.
And in this case, you know, it needs to maintain those rear side and front yard setbacks, and if it doesn't, the dimensional variance is required.
All right. Okay, thank you. Okay, any other board members have any questions or concerns for the applicant? Anything from staff? Ms. Pellerin, did you want to add anything?
No.
Okay. All right, this is a public hearing. If anyone in the audience had any questions or concerns, they would need to raise their hand now. Okay, seeing none, do I hear a motion?
I motion that we close the hearing.
Second.
Okay, so I have a motion from Mark and a second from Brad. Roll call, Mark? Brad?
Aye.
Paul?
Aye.
Dick?
Aye.
Fran, aye. And I will say Mark raised his hand, but he was on mute. Sorry. All right. So Ms. Pellerin, we will get to this before
right.
the end of our meeting tonight. You can contact the town planner's office to find the status out as soon as possibly tomorrow.
Okay, so I don't have to stay till the end of the meeting then?
No, I wouldn't if I didn't have to.
Thank you very much for your time. Have a great night.
Thank you. Okay, the next one on the agenda is to consider the petition of William and Christine Poutier for the variance special permit with site plan approval, special permit groundwater protection overlay district to construct a two-family dwelling at 399 Hudson Street, map 30, parcel 81, located in the residential C zoning district and groundwater protection overlay district area 3. And do we have the,
No, I'll get it. I'll get it for you.
you get what? All right. Oh, so well, I need to find them first. So let me
Yes,
find
I'm
them.
sorry. So you
Okay.
have Peter Bemis
Okay, 1 second.
on the
Okay.
line, and I also believe
There's Peter.
the applicant is there, Bill Poutre.
Good evening. Peter Bemis is here, and I know Bill was on by phone.
Okay, do you know what the last 3 digits of his phone number are?
Just bear with me. I can get that for you.
I'm going to guess 148.
Oh, I was going to say 265 because I don't see a 148, but
Yeah, I have 148 for his mobile. If you don't see that, then it must be the other number that you have. Oh, 148. No, he just texted me back. 148.
okay, let me see where it is. All right, maybe he's in there by name. Let me just try again. I don't see.
Last name is Poutre, Poutre.
All right, I only have one phone number in my attendees. And it ends at 265.
Oh, just bear with me. I'm going to call him.
He's not Bill at Prime Finance, is he?
That's it. That's it.
Oh,
Bill
well,
at
okay,
Prime
there he
Finance.
is. Okay.
Thank you.
I think he's in now.
I'm in. Yeah.
There you go. Sorry about that. Okay, Bill, if you could state your name and address for the record and who you have brought with you.
Sure. I'm William Poutre, 8 Redgate Lane, Southborough, Mass. And I'm here by myself, but representing my wife and I.
Okay. And with you is Peter Bemis?
Yeah, I'm
the
Peter
engineer.
Bemis.
Okay.
Yeah, I'm with Engineering Design Consultants, and a petition was filed by our office on behalf of the Poutre family. So this is 399 Hudson Street. This was part of an approval not required subdivision the planning board recently approved. There were single family lots and then this larger lot that was created for a duplex. And we filed with you under 2 sections that were identified by your building inspector. 707-01D3C6, a 2-family use within a groundwater 3 district.
Okay.
And then 70305A2, special permit for a site plan review.
Okay.
As part of our proposal, we had developed a site plan that was submitted as part of the package. However, the one that Kathy has so kindly put up for you tonight is the one that has kind of evolved from the discussions with the town engineer, Fred Litchfield, and then having met with design review. most recently. So if you don't mind, rather than me describing the original site plan that was submitted, I'd like to just describe the one that's appearing on the screen this evening.
Okay. All right, and if we could just make the site, the map piece of it a little bit larger, Kathy, unless we really,
There you go, Kath. Good. So I'm assuming that folks know where we are on Hudson
Yep.
Street, roughly for Locust. And so we are on the west side of Hudson Street, and again, the proposal for the duplex is somewhat centered on the lot, and we're proposing to have basically a loop driveway here. The original submittal was for a wider driveway entry at Hudson Street in the turnouts, and this is just, I think, we actually have less pavement. It's a little bit more desirable, and then giving us the opportunity to put a screening area. So there's a large planting bed that would go in front of what would be the garages as the house is sold along Hudson Street. There's a turnout to the left and the right. You'll see the soil absorption systems for the unit B on the right at the rear, and then unit A on the left to the front. And then we've got a stormwater management system where we're collecting the roof water from both units, infiltrating it on the east and the west side of the buildings. And then we're also collecting the stormwater from our proposed driveway and infiltrating that on the northeast portion of the lot. So we're mitigating all of our stormwater impacts as a result of the proposal for both roof and driveway. And we comply with all other requirements for this intended use on this property, in that it's a 30,000 square foot lot, has its requisite frontage, meets all of its side, front, rear yard setbacks. Fairly close to existing grades within the site, so there's not a great deal of cut. All soils would stay on site. We don't have to haul off anything. We're just going to go cut to fill. There's a slight cut on the west and a fill to the east. The architecture was provided to you as well. So it's a craftsman style building. And I believe you would find it in harmony with the neighborhood. It's a pretty classic style building envelope that's being proposed. The builder that's going to do this project is going to do a fairly high-end development here. It's quite nice. So if I can answer any questions regarding architecture or the site plan, I'd be happy to do so. Thank you.
thank you. Okay, board members?
Madam Chair.
Yes, Brad?
Yeah, so I actually drove by this property and drove up and down the neighborhood and noticed that there aren't any duplexes there. And so I have to disagree with the fact that it's in harmony with the neighborhood. Looking at the plans, the building looks beautiful. So that is in harmony, but the fact that you're adding 2 additional driveways onto a main road, and I have to ask, why didn't you just put a single family home here?
Bill, did you want to say something first, or do you want me to respond?
Glad to speak to that. As far as why we didn't put a single family home there, we live in Southborough, and I think that we, in speaking to a lot of the families in the joint school district of Northborough and Southborough, the people that are, 40 and 50 something, the empty nesters are looking for a different property type. And they're looking for a property type, and I fit into that category. I've got 2 kids in college, and we don't need the single family larger house anymore. And so in speaking to others, it's one that's in high demand. There are a couple properties very similar to this in Southborough. And as far as with the neighborhood, there is a 2-family that was approved right at the corner of Solomon Pond Road and Hudson Road, maybe 6 or 7 houses down. And that was approved by one of the boards not long ago.
So the thing I was going to say is I didn't mean to interrupt Mr. Blanchett.
No, go ahead. No,
note that there were a few that I had seen, at least in this zoning area, because the RC zone does afford this opportunity when you have 30,000 square feet. So it's not unique in that it's a single. I'm not sure how many units there are because I didn't be prepared to answer that. I only can tell you that I have seen them. I am familiar with that use being allowed and being evident in town. You have a reason, it's in the zoning bylaw and there's a reason for it. And I presume that that's why it was put there, was to take advantage of it.
No, absolutely. I mean, I know
Okay.
by right it is allowed there. I was just looking at the corner of, well, it was Hudson to Solomon Pond by the kennel, and then going towards Boundary Street. I didn't see any duplexes, but going back to your question about being an empty nester. So what's the square footage for each unit? I know it's a two-family, but what's the square footage for each?
I have it in front of me, but it's 22 or 2,300 square feet. I don't recall exactly. I don't have it in front of me.
I'm looking, I'm trying to get to the answer without delaying you much further, so bear with me a moment.
And I know we're not deciding on the duplex or not. That's not in front of the board tonight. It's just the impervious coverage, the additional impervious coverage. But I'm also concerned about the two entrance exit ways off of Hudson Street. I know that's it's a busy road. So those are my concerns. I obviously the duplex thing that's not in front of our board, and that's not what I'm gonna decide on tonight.
Okay, well, regarding the driveway, so Fred and I have gone through this a couple of times, and I'm certainly fine with going back to a single if that was the sentiment of the board. We did start with that program. I just saw this as being a really nice opportunity for having a loop, and always wanting one personally. I just thought it would be kind of a nice touch. And when it laid out that way, I had suggested to Fred this would be more attractive. The builder that's going to do the project found it more attractive and gave us the opportunity to have less pavement at the end. The second time I looked at it with this proposal, with the way Fred had asked me to do it, I don't think there's going to be that much more pavement if we came in with the single and did the same looping left and right. I just think instead of coming into the site, you're going to see the garage doors if you come up the middle, whereas coming up the sides, it just gives you a different perspective. So I'm open either way. I'd like to go with this program the way it's drawn, but if folks really want the single, I'm fine with that.
Nope. I mean, again, I saw the drawings. The building looks gorgeous. Sorry, I just had a couple other questions away from the actual design of the building. But thank you.
Yeah, thank you.
All right, well, thank you, Brad. Other members? Paul?
So I guess, I mean, what is the impervious surface square footage for the building and the driveways?
Yeah, so when we did the original design, I think we were around 4,100. And that's what the stormwater mitigation program is based on. This one that's shown before you tonight is 3,500. So it's considerably less.
And the 3,500 includes the building plus the driveways?
No, that's the driveway, the buildings, their footprints. I was trying to find that too. It's in the drainage calculation, but we're basically infiltrating 100% of our areas. The roof area will direct discharge, whereas the driveways are collected and then treated. There's a Contech CDS unit there that will treat the stormwater prior to recharge. So essentially, we're putting all of the impervious areas back into the ground. So we're trying to have a fairly zero impact to your groundwater protection district.
Okay, thank you.
Thank you.
Thank you. Other members? Dick?
All set.
Okay. Mark? Okay, well, I have a
I'm
question.
okay.
Oh, all right. So we have a letter dated September 3rd from the town engineer that had some open-ended issues. I'm just not sure whether is this the most recent correspondence, Fred? Have the questions that you had in this September 3rd letter been answered? This was to the groundwater advisory back on September 3rd?
The September 3rd letter is one that I had written to the Groundwater Advisory Committee when the applicant was coming before them with the initial plan. As a result of the meeting and revisions that the applicant has made, I had written another letter dated September 18th and forwarded that. I thought you would have it. And so maybe
All right,
in your
well-
file, there's another letter, Fran.
All right, well, while you're here, do you want to just let us
I do.
know what you think in case other people don't have it like I don't?
Yeah, I don't have it either. But
Okay.
Okay.
See that
wow.
Debbie retiring? Look what she's done to us.
You know, you couldn't be more closer to the truth there.
Saw Debbie today. She looked happy.
I'll bet she did. And
Okay,
she's
so Fred,
probably home watching TV.
Recap,
Anyways,
please.
the letter that I wrote on the 18th has a number of the same comments that were in the September 3rd letter to the Groundwater Advisory Committee, but the applicant did address most of the concerns. Some of the comments in there are typical comments that should be in the ongoing in the decision and be a part of any decision. The first comment had to do with the applicant had originally not submitted all of the information that's required for a special permit, but he did supply information and he did verify that the engineer who did the design on the drainage system was a qualified expert and there is no impact to the groundwater. The drainage that they're proposing is within the state guidelines and does meet the bylaw. So, and they are recharging 100% of the lot, which is not typical. Usually people try to recharge the roof runoff because it's the easiest to capture, and the driveway runoff is not generally recharged because it requires water quality structures that are a little bit more expensive. And if you can get under the 15% limit without recharging the driveway, most people do. So this engineer and developer went above and beyond in that regard. The second comment has to do with the size of the septic system. The bylaw, the groundwater bylaw limits the septic loading to 220 gallons per 10,000 square feet. The lot has just over 30,000 square feet, so he's limited to 660 gallons per day for septic loading, which effectively is 6 bedrooms total for the duplex. Whether it's, I believe they're proposing 3 and 3. The Groundwater Committee had a lot of discussion about how to limit that. There was a lot of discussion about closets and could they be considered bedrooms and could it be sold or marketed as bedrooms. And the building inspector and I have talked about it, and some kind of a deed restriction and something in the decision that indicates that the number of bedrooms cannot exceed 6 in total for the site, and that I'm not sure what else you can do. The applicant agreed to modify some clauses, but did not want to eliminate windows or anything that would change the architecture of the building, which I can understand. So I would leave it to the board to be sure and stipulate the 6 bedroom maximum for the site shows up in the decision and shows up as a reference in the deed as well.
And of course, the as-built plan is always part of a decision. That was something that you had also indicated.
Yes.
Okay.
Yes.
All right.
The number of bedrooms is tricky because the septic system could be designed for something larger than 6 bedrooms. It's the bylaw, the groundwater bylaw, that limits it to the 6.
Okay. All right.
My letter goes on to talk about the fact that the applicant indicated that the buildings would be heated by natural gas or propane, so that should be a condition. The drainage calculations were submitted after the Groundwater Committee met, but they do meet the requirements of the bylaw. He did amend the driveway as discussed at our meeting to remove some pavement, and what he had before was just a very standard block that projected out from the garage, leaving a 48-foot wide driveway opening in Hudson Street, which I felt was inappropriate. I am recommending that one permeability test be done in each area that's to be utilized for infiltration. The applicant must confirm the bottom of the infiltration areas are a minimum of 2 feet above any signs of groundwater. Stormwater operation and maintenance plan shall be submitted and shall include a copy of the manufacturer's maintenance manual for the water quality units. The stormwater operation maintenance manual shall also include a blank inspection report so that someone reviews the drainage, makes sure the system is working right, fills out an inspection report and hands it over to either the homeowners or if the developer is going to live there, however the ownership is going to go, that somebody knows what they have to do on an annual basis to submit those reports to the town. If there's any changes to the drawings, a final set of plans verifying all conditions have been met would be reviewed and approved by me prior to the construction of the building. And then the last one is my very standard lengthy paragraph about the as-built plan and what's required to be included with that as-built plan at the end prior to the occupancy.
Okay, so Mr. Bemis, have you received that letter from the town engineer dated September 18th?
Yes, we have, and all of the conditions that Mr. Litchfield had outlined were acceptable and
Okay.
and expected. So I
All
have no problem with that being a condition of approval if you were so inclined to support the project.
Okay, perfect, thank you. Okay, any other questions or concerns from the members of the board? Okay, we can always circle. Oh, Kathy, Kathy, you or Bob, anything?
Yep, I just wanted to add in that this is one of the, we've had this once before where an applicant is having to go before both the planning board and the zoning board of appeals for site plan approval. And so that's something I'm going to work on some language on for that for the town meeting, because it's redundant obviously for the applicant and for both boards to do the exact same thing. But that said, this applicant is before both boards for the duplex, for site plan approval, and he has been to the design review committee, which is part of the site plan review process. And the design review committee was very much in favor of the proposed design of the duplex, and I just wanted to share that with you.
Okay, with the the loopy driveway?
Yes,
Okay,
that's what they discussed was this particular plan in draft form as far as the driveway locations.
All right, and the planning board has had their hearings already and they're done?
Actually, the planning board will have their hearing on this next Tuesday night, October 6th.
Okay, but
So
ours is separate to this. This is not where we're, so we can make our own decision tonight.
Yes. Yep.
And they will make their own on separately. Okay, I just wanted to make sure that we didn't muddy that water. Okay. Any other questions or concerns from board or staff? All right, I'll circle back around if need to. This is a public hearing, so if anyone in the audience would like to make a comment or ask a question, I need you to raise your hand. Okay, seeing no hands raised. Any circling back to board members? Questions or concerns?
Madam Chair, so just to confirm, design review approved this and groundwater special permit was also approved as well. That's correct?
Yes.
Correct. That was correct. Okay. All right.
That's all.
Okay. Do I hear a motion?
Make a motion, we close the hearing.
I'll second.
Okay, so roll call. Dick?
Aye.
Mark?
Aye.
Paul?
Aye.
Brad?
Aye.
And Fran, aye. Okay, thank you very much. Hopefully we will be able to wrap this up before the end of the evening, and you can contact the planning office for further instruction.
Thank you. Good evening.
Thank you. Have a good night.
Good night now.
Okay. The next is to consider the petition of Susan Woodland for a variance special permit with site plan approval, special permit groundwater protection overlay district to construct a detached garage with an apartment and add second floor living space to the existing house at 11 King Street, map 82, parcel 24, located in Business West zoning district. Okay, so let me see who we have here. So I'm going to assume the Woodlands are somewhere. Let me see if I can find them. Okay, I see a Susan Woodland. I'm going to, hopefully I just allowed you to talk.
Yes, you did.
Oh,
Can you
okay.
hear me?
And is there somebody else with you for this application?
Yes, my son, Bill Norman.
Okay, give me 1 second. Is it going to be Bill or is it going to be William? I think
It could be under William.
Oh, nope, there he is. He went Bill. Okay, I got him.
He's going to
Okay.
be
There we
speaking
are.
for us.
Okay, all right. Well, I do need you each to state your name and address, and then we will let your son go ahead.
Okay, my name is Susan Woodland. I'm currently living at 23 Boxwood Drive in Littleton, Massachusetts.
All right, thank you. And with you is?
Bill Norman, 11 King Street, Northborough.
Okay, so Mr. Norman, if you want to tell us a little bit about what it is that you and your family are proposing.
We want to add a detached garage with a studio apartment for my mother to move in with us, and then and go on top. So we have a single level ranch. We want to just go up a level and put all the bedrooms upstairs.
Okay, and why are you before us this evening?
Well, when we started looking into this, they said because we're in the Business West district that we needed to get the special permit.
Is it because of the size of the addition?
I'm not sure. I'm just you guys told us to do it. So
All
I think
there you
maybe
go.
because it was a detached or an
All
additional dwelling, maybe.
All right, well, why don't we get you some clarification from our zoning enforcement officer?
Okay.
Bob?
Good evening. What they propose to build is an accessory dwelling unit. And it's going to be in a detached structure, which is allowed, but in the particular zone that they're in, it requires a special permit from the ZBA.
Okay, all right, and so for accessory dwellings, they have to be 750 square feet or not more than 25% of the current footprint, whichever is less?
700, not 750.
700, I'm sorry, 700.
Yes,
And
700 to 25%.
okay, and since they are adding to the original structure, then is it 25% of the original or once the second floor is added?
If they're doing both projects at the same time, it will be when the original house is completed.
Okay, all right, so Mr. Norman, what is the anticipated size of the main house before you attach the garage and studio apartment?
So it's 1,100 square feet now, and we did a plan based on a 700 square foot detached building.
Okay,
because
so
we thought it was going by the original structure.
Okay, all right, so then you'll definitely be small within the 25% of the big one.
Yeah.
Right, and 700 is, well, are you going straight up another 1,100 on top
Yes.
of 1,100?
Yes.
So what is 25% of 2,200? Somebody wants to ask a question while I'm doing that.
But we're at the 700, right? So isn't that the?
Well, it's
the
whichever
maximum?
is smaller.
Whichever is larger.
Larger, sorry. I had
Larger,
it backwards. Okay. Okay, so does anybody have questions? Okay, town staff, do you have anything you want to add? I feel like something's gone wrong with my.
Sorry,
No,
Madam Chair, just a quick question on the
Sure,
septic.
Paul.
Bob, so it says septic system shall be certified to accommodate new bedroom. Does that mean it needs to be replaced? Like, does the current septic system able to handle the new addition?
No.
It will have to be modified to accept the new addition. or they'll need to tie into sewer. The septic system
no sewer
needs
there.
to be, if they're going to amend the septic system, that has to be approved, the plans approved before I can issue a building permit.
What would be the steps to, I mean, I'd rather tie into the town sewer if that was an option.
You'd have to check in with the DPW on that one.
Okay.
I'm not familiar with where the pipes are in that particular section.
I don't believe there's any town sewer on King Street.
But when we bought the property, I believe that somebody asked on my behalf, like the realtor, and said that it's an option if we, because we're right at the corner of Route 20. We might be able to go down the hill.
Oh.
But that was a few years ago, and I don't know how true that was, but I guess we can ask the DPW.
Yes, if you contact me tomorrow, Bill, I'll try to help you out with that.
Okay.
Okay, so in the meantime, though, the septic would have to be either upgraded or something enhanced in some form to accommodate the additional bedroom.
Right.
Right.
Okay. And the whole house to comply with alarms as for now? Bob, can you,
Oh.
I can't read your handwriting.
Yeah, it's just somehow there was a lot more information than required on there.
Okay.
Whenever you're working on a house and you're adding or changing or creating a bedroom, regardless of when the house was built, the smoke alarms, carbon monoxide alarms, and heat detectors have to be upgraded as if it was brand new construction in the house. So if it's an older home like the first floor, they're going to wind up having to retrofit the whole house.
Okay. All right, and you're aware of that, Mr. Norman?
Yes.
Okay, and that's all part of the building permit process.
Yeah, it's all part of the building. It's somehow it wound up on a piece of paper for you guys, but
All right, not a problem. Okay, any other questions or concerns by the board members and or staff? Okay, hearing none, this is a public, I'll always come back to you. This is a public hearing. If anyone in the audience has any questions or concerns, please raise your hand now. Okay, seeing none and seeing our attendees are dropping like flies, I will assume there is no further comments. Do I hear a motion? Someone.
I make a motion, we close the hearing for 11 King Street.
Thank you,
I'll
Brad.
second the motion.
All right, thank you, Mark. Okay, roll call. Brad?
Aye.
Mark?
Aye.
Dick?
Aye.
Paul?
Aye.
Fran? Aye. Okay, we are closing the hearing. We'll make our decision within the next sometime tonight. I guess. Okay, so moving on.
Thank you.
All right, thank you.
Have a good night.
Okay, sorry, I'm just moving as quickly as possible. All right, the next is to consider the petition of 920 LLC for a variance special permit with site plan approval, special permit groundwater protection overlay district to construct a 3,000 square foot bank and automated teller machine with drive-through to service the bank and ATM at 10,000 to 10,010 Shops Way, map 109, parcel 15. I think we've been keeping the groundwater advisory committee pretty busy these last couple of months. All right, so in the audience, I saw someone from Gould and Ettenberg, which I believe is legal counsel. I saw Capital.
Also Capital Group Properties.
Okay, and there's a couple for Capital Group, so I'm gonna.
Yep, there should be a
Oh, there's another group. Okay.
Bob DePietri and
Danny Ruiz.
Danny Ruiz, right? And then Jim Almonte is their
Yep. Okay,
engineer.
All right, so is that, do I have anyone, am I missing anyone?
No.
So there should be the four of them.
I saw one other person whose name I recognize, but maybe he left. Okay, all right. Just state your name and your relationship with the application, and let's get moving.
Okay, thank you. Marshall Gould as attorney for the applicant. It wasn't stated, but Jim Almonte is with Land Design Collaborative. He will present any engineering that's needed tonight on the site design. Background here, this is all part of Northborough Crossing. I don't know if you have all gone up to look at the site, but this is in the lower section of Northborough Crossing. The newest section to have been built where the restaurants are, and there are a couple of medical offices that are up there. And when the site was first permitted back in 2014, in decision 14-12, there were a variety of special permits and variances, one of which was to allow a 2,000 square foot bank building along with an automated teller machine. And there was planned to have a drive-through. And if you drive into the building now, and I think at this point it might be a good idea to, well, let me give the introduction and then we're going to go show you what the site is and we'll show you where everything is. So if you first drive into that site now, you remember there used to be an Anthony's Coal-Fired Pizza, and there was and still is a medical facility. Right now, the coal-fired pizza place is out and Mattress Firm is in, and the bank was going to go in that building originally.
Okay.
But because they had other people who wanted to be in that building, they did not go forward with that as a bank with a drive-through. So there was a subsequent change to that. And in 2015, in case 15-11, it was voted to modify so as to allow an additional 3,000 square foot building with, it was going to be a restaurant, but with a commercial amusement use. It was going to be a restaurant that had certain video games and other entertainment products on the inside. And what we did was we withdrew at that time the application or the use of a proposed bank, ATM, and drive-through. Now what's happened with the pandemic and with restaurants going through major changes, I'm sure if you've been up there, Applebee's and Margaritas right now not open. Applebee's did close, Margaritaville is still open, but they are not open at the present time due to COVID-19. There is a building that was planned back when the revision was done that was going to be where this restaurant and commercial amusement use was going to be. And it was going to be kind of in the back in the middle. So we'll show you a site plan. Danny, if you want to put that up at the present time so that everybody can see it. Kathy, I don't know if you have to allow him to do that or how this works. But I will continue talking. When you drive in, the location of the buildings, we're going to refer to them by the letter R followed by a number. So as you drive in, the first building on the left is actually R5. That's where the medical center and Mattress Firm is now located. As you drive back into the left in kind of an L, there are two buildings back there, and those are buildings 1 and 2.
Marshall, 1 second. So I can't share the screen right now. I think Kathy has to allow me to do that so I can show us the plan.
No, actually, I don't have that. I don't have that power. But either Fran or David can.
David does. I'm sorry, Kathy, you're not going to share. Who's sharing the screen? Who needs to share the screen?
Capital Group.
Yep, I just raised my hand.
Okay, we're going to move you in as a panelist, and then you'll be able to share your screen. Just a moment, please.
And Marshall, just, I'm not sure if you've come before the boards or committees during the virtual, but we need to try to wrap up our meeting within the next 45 minutes. So
That should not be a problem at all.
okay, all right. Thank you.
Okay.
Well, you don't get the whole 45 minutes.
I understand that. I think hopefully we will be in about 10 minutes or less.
All right, thank you.
As you're looking at the site now, if you look at the top right of the site, you'll see the four-way intersection, and that is down at Route 20. And then as you drive up to the upper, on the top going to the left, you're driving up the way known as Shops Way, and on the right, you will see the Burger King and the Starbucks, and on the left, you will see a series of buildings, some of which have some yellow directional markers. That's the 19-acre site that comprises the restaurants and some of the retail uses that we're talking about now. So as you drive in there, the first building that you can see there, if you can see it, is labeled R5. That's originally where the bank was going to go with a drive-through. That is now a medical office, and it is Mattress Firm. As you continue up in a counterclockwise direction, the two larger buildings, R1 and R2, are both retail and a mix of restaurants and medical. The smaller building that, as you continue to go clockwise, that is R6. That is the building that we're going to be talking about. And when Jim comes on, he'll show it to you on a larger scale, and he'll show you the traffic pattern. And beyond that are the two buildings that were Margaritas and Applebee's, respectively, R3 and R4, respectively. So originally, the restaurant with commercial amusement was going to be in building R6, but for a variety of different reasons, they held off going in. And once this pandemic came about, they said they are not going to come in. So there have been banks that have expressed interest. The bank that does want to come in is a bank with locations in Worcester County and other places in Massachusetts. It's primarily a Massachusetts bank, but they've asked that we not disclose their identity at the present time. But I can tell you it is not a Bank of America or a large bank like that. It is a friendly community bank that wishes to go in here. And so what they are going to want to do is, instead of a 2,000 square foot building, they want to have a 3,000 square foot building, which will include 2 lanes to drive through, one of which will be for a teller and 1 lane of which will be for an ATM that can be used at all hours. Jim will walk you through the actual drive-through. I will just give you the information. This bank will have 4 full-time and 1 part-time employees. Their office hours are going to be what we would typically call commercial office hours, Monday through Saturday. They do not yet have in their plans any evening hours, but certainly where this is located, a lot of the other businesses and restaurants are open evenings if they wanted to. We are not looking that they be limited to 8 to 5, but I just wanted you to know what their current hours are going to be planned. They will be able to open even during the pandemic compared to the restaurants, most of which are holding off. So going back to what permits were originally allowed, 1412 allowed a bank drive-through and 2,000 square foot. On case 1511, it was modified to allow the commercial amusement use, and we agreed to remove the bank and the drive-through from the use up at the property. However, the decision in 1511 did say continuing to allow retail, bank, medical offices, and restaurants, but the drive-through was removed from the plan. So I want to just make one clarification from the advertisement on this. The advertisement for this appears to say that we are, and on the actual application, they put special permit with site plan approval. But in fact, according to Bob in his zoning opinion, what we're actually looking to do is to amend special permit 15-11. If you want to call it a new special permit, I can live with that, but Bob's zoning opinion does say to amend the prior permit 1511 to reinstate the approval for the bank with a drive-through and ATM. And that's all we are looking to do. In the past, I'm not going to repeat this all. You have already had traffic studies presented. The traffic studies are exactly what they would have been in 2015. And as a matter of fact, the bank will have less traffic than a 3,000 square foot restaurant that had a commercial amusement aspect to it. So besides those changes, that's all we are looking for. Jim, I'd like to turn it over to you now, and you can just talk about the site and the traffic and the parking and the drive-through.
Sure. Thanks, Marshall. My name is Jim Almonte from Land Design Collaborative. I am the registered landscape architect on the project. So from an engineering and site plan standpoint, it's pretty straightforward, pretty simple. Basically, what we're doing is reconfiguring some of the curbing and landscaping and traffic patterns around the building to accommodate the drive-through at the back of the building. At the rear of the building, the traffic patterns change from a two-way driveway to a one-way driveway to accommodate a drive-up ATM, a drive-up teller, and a bypass lane. And what you can see on this plan here, we have queuing for about 10 vehicles. I know there was a traffic memo that was issued saying for a bank, typically 1 or 2 vehicles queued up is typical. So we have more than adequate queuing for the vehicles at this location. They'll also be adding a canopy at the back of the building to cover over the drive-through lanes, as you would typically see. One to completely cover over the drive-up ATM, which is adjacent to the building, and then the middle lane, if you will, is the drive-up ATM. The canopy will cover a portion of that location. And then the bypass lane will be separated from the drive-through ATM with a landscape median, as you can see on the plans here. And then to direct traffic, we'll have directional signage. There'll be 2 do not enter signs at the south of the bank. There'll be a left turn there where Danny has the cursor. And then to the south of the building, we'll have a sign that says no right turn as well. So there'll be more than adequate directional signage to move vehicles through that site. Directly against the back of the building, there are currently 7 parking spaces there now that will be eliminated for the drive-through lane. And then directly across from that, where Danny's cursor is now, there's 90-degree parking that will be restriped to angled parking, which will work with the one-way traffic pattern now. So we'll lose 7 spaces up against the building. By restriping, we'll lose 4 there. And then at the top of the sheet, the dumpster will be relocated. Right now, it's currently where the vehicles make a left turn to go around the building. We're moving that to that location where Danny is indicating, and it'll be much easier to get access to that dumpster. So we'll lose 2 more spaces there for a total of 13 spaces lost. So when this was initially permitted, the entire site was permitted for the most intensive use. So when it was permitted, 446 spaces were required. We're losing 13 spaces, but we still have 485 spaces for this entire area. So more than adequate parking here. By reconfiguring some of these landscape islands, we actually have a slight decrease in impervious surface. The grading and drainage patterns will remain the same. All utilities will remain the same. We'll provide additional landscaping in the areas that we're removing pavement. I believe we'll have to relocate one light pole into a landscape island. So from a site standpoint, it's pretty simple. We're basically just accommodating the drive-through lanes at the back of the building. So, this is at the back of the building. We're about 500 feet from the nearest Avalon building, which is to the west, and it's separated by pretty dense woods. Beyond that, we're about a quarter of a mile to the nearest residence in Shrewsbury. So it's pretty far away from any residential uses. So this plan here shows the potential traffic patterns to get to the drive-through. As you enter the site from the 4-way intersection from Shops Way, you could take your first right to head towards the restaurants at buildings R3 and R4. And then you can take a left in front of the restaurants and then a right in between R6 and R3 to work your way to the back of the building. You could also take that first right, and then work your way around the backs of the restaurants, R4 and R3 to get to R6. Or if you miss that first right-hand turn, you can continue to the next intersection, make a right in front of the bank, and then a left along the side, and then around the back, and then out. So that's basically it from a site standpoint. So I will pass it back to Marshall at this point.
And Danny, I would just ask that you put up the plan that shows the colored rendering of where all the stores and everything are, not that one, the full one that we had. Yeah, this is what the site actually looks like now. And it shows where the proposed bank is going to be. And it shows what everything is there. Up where Applebee's is, it's Flynn, but that's Flynn Restaurant Group. So if you've been up there and you know some of the stores, that's what it's going to be. And as we say, what we had shown to you back in 2014 and then revised in 2015, the traffic was actually going to be more intense based on the commercial use restaurant with the amusement aspect. It's now back to what it was in 2014, but the additional parking spaces had been built to accommodate the more intense use. So even though we're losing 13 of the totally built spaces, we're still way over what was needed in 2014.
Okay, thank you.
And I think that's our presentation, unless Danny or Bob have anything that they want to add. And it sounds like no, so I guess we're all set.
Okay, board members, do you have any questions or concerns for the applicant? Paul, oh, I can't tell if you're reaching. Okay, all right, so I have a couple of questions. And I think unless Bob can just give me justification not to do a new special permit, I'm a little concerned with amending the 1511 one, because there are places where the bank is referred to as 2,000 square feet, not 3,000. It's not just amending it to say that the use of the drive-through to service could be reinstated, because the bank is not in R6 where, it's in R6 where it was originally supposed to be in a different building. So does that get like complicated? Do we have to make sure we amend every reference to the bank, not just reinstating the driveway? But I'll defer to Bob if you can explain to me why that
Either way is
okay.
okay with us, just so you
Right.
know.
Right.
I think it's up to the board to figure out which way you'd want to go with that. If you were to amend the current special permit, you'd have to be careful to make sure that the new language is appropriate and reflecting of what they want to do and not what was done in the past.
Right.
I don't know how much wordsmithing that is going to entail. And I don't know if that's a thing where where staff can work on that to make sure clerical wise it's
Right.
accurate.
Okay, so it's cleaner to do a new special permit?
It may be.
Okay,
It may be, considering the circumstances.
okay, all right. Board members, any comments or suggestions relating to that?
Fran, can I
Sure,
make a
absolutely,
comment?
Kathy, sure.
Just looking at, and as the one that's going to write this, just looking at the 2015 ZBA decision, there appears to be just one condition that refers to the bank, and
Yep.
where it's actually condition 1 if anyone has that decision, and in part it reads, to allow the addition of a 3,000 square foot building and to remove a drive-through to service a bank or automated teller machine. So I think to remove a drive-through to service a bank might be the only amendment that's needed on 1511, and then on 1412.
So it doesn't matter that the, well,
And then 1412, there is one, again, I believe it's just one condition, that it's condition 9, which talks about to allow the use of a 2,000 square foot bank or automated teller machine on the property located at 370 Southwest Cutoff. So the address has also changed. You know, we refer to the to any of these buildings on as Shops Way.
Right.
So I think it would be pretty straightforward for you to, if it was to amend, you know, both of those, you know, former ZB or past ZBA decisions.
okay, so, well, I mean, I guess when I look at 15, the
11.
decision, I mean, again, the reference to the buildings would be different. And it says, or, a bank or an automated teller. This is a bank and an automated teller,
That's the
Right.
wording in the zoning bylaw, Fran.
which is,
If you want to do a bank or ATM, you need the permit.
So the,
okay,
But you can make
so
it
I
in.
would advise you that the, you know, that the change would be that you, in 1511, that you are, you know, amending condition 1 to allow a drive-through to service a bank and to include, you know, an ATM machine.
okay,
And then in 1412, you're amending the decision, which right now is condition number 9, to allow the use, the decision states 2,000 bank or automated teller machine. And again, we're going to say to allow, well, I'm anticipating that you would be saying to allow the use of a 3,000 square foot bank, including an automated teller machine.
right. I would also want the references to R6 to not say restaurant use. Because it's not a, the decision is not to allow it for a restaurant with a drive-through, that it could end up being a Starbucks. So anyway, other members of the board, any heartburn one way or the other on whether we consider this as an amended or a new special permit, regardless of whether it's approved or denied?
I
Mark?
guess my own feeling is that we go with the amended, simply
Okay.
because it seems like everybody's thought of it in that direction.
Okay, okay. Anyone else? Okay, given the hour is late, I'm just going to move us into the audience, just on the off chance there is somebody still there that is interested in speaking on or against the application in front of us. Okay, seeing none, do any of the members have any additional questions or concerns about this application? And, or want a motion to close the hearing and decide how it will be addressed afterward?
I move that we close the hearing.
Okay, Mark,
Second.
Dick seconding. Okay, roll call, Mark,
Aye.
Dick,
Aye.
Brad,
Aye.
Paul,
Aye.
Fran, aye. Okay, so we'll close the hearing. We will get back to this unless we want to do work from the back forward. See if we can't roll through these.
I would approve of the going from the back forward, yeah.
Okay, so while this is fresh in our mind, let's first determine whether we are in favor of granting the request. And then is the preference amended as town staff seems to feel that is doable from a wordsmithing standpoint? Or do you want a new, do you see merits in a new special permit? Someone.
I guess I'm in favor of approving as amending the thing, since town staff seems to be less bothered by that.
Okay, all right, thank you, Mark. Anyone else have any concerns or issues with that approach? Dick?
I'm in agreement with that. I think it's the
Okay.
simplest way.
Okay, all right. And
Yep. So I agree. Just to piggyback on that, I think it's the easiest and cleanest. I mean, you bring up great points, Fran. So as long as we're covered in that sense, being a Starbucks versus a bank, but I'm in favor of I'm in favor of whatever's easiest and cleanest, and we're just dotting the I's, crossing the T's.
fabulous. Okay, thank you, Brad.
Probably be a Dunkin' because there's already a Starbucks up there.
There you
That's
go.
well, that's true. I know.
That's true. So, all right. Okay, so hearing no real issues or concerns, do I hear a motion?
Make a motion to approve the petition for 920 LLC for the variance, the special permit with site plan approval. Special permit groundwater protection overlay to construct the 3,000, are we amending?
Yeah.
Yes, we're amending just the special permit.
Sorry,
so-
amending the special permit from operational.
Case 14-12.
Amending the special permit from case 14-12 dated November 14th, 2014. And do I have, and 15-11 dated
Yes.
August 27th, 2015?
Right, and what are we amending? The language.
Amending the language regarding, where is it?
Drive-through and ATM.
Drive-through
banking.
ATM and banking. Yep, sorry.
That's fine. Is that enough for you, Kathy, to work with?
I'm sorry, Fred's wondering if there's, go ahead, what is it?
You have to unmute.
Yep, I'm unmuting. I'm looking at the decision and there's a reference to ZBA case number 14-14 to reflect the amended special permits from case number 14-12. Just want to make sure that that's also referenced in any amendment that you grant tonight.
Where are you?
On page 5 of 7 in the permit from 15-11.
So we have 14-12, 14-4, and 15-11.
14-14.
14.
14-14.
We don't even,
At the very bottom, Kath?
right, but we're not, they're not amending 14-14. They're amending,
I think each one amended a previous one, and for 15-11 is probably the right one. But 14-14 amended 14-12, and then 15-11 amended 14-14. And somehow you went back to 14-12.
That was a site plan decision.
yeah, 14-12 is what specifically talks about, because I went through all of this with Danny.
I just want to make sure you didn't skip one, that's all.
So we're good.
My bad.
Right, so, no worries. So the intent of the motion is to ensure that all previous language is either amended or stricken to reflect that the bank with a drive-through teller is now at 3,000 square feet is allowed with the traffic pattern on this site plan. That's the intent anyway, right?
And
Yes.
ATM.
I'm sorry, Marshall?
And ATM.
ATM, okay, yes. All right, drive-through and ATM, correct. Okay, so Paul has made a motion.
I'll second it.
Mark will second it, and we'll do a roll call. Paul,
Aye.
Mark,
Aye.
Dick,
Aye.
Brad,
Aye.
Fran, aye. Okay, thank you very much, gentlemen.
Thank you very much.
Thank you very
Okay. All right, so now we're up to King Street. Okay, so on the King Street, we're talking about the two-story, making it into a two-story home with a garage and an apartment above the garage. And it's a special permit. It meets the, okay, any concerns or questions people are in favor of or opposed, and who would like to start the discussion? Come on, we're on a home stretch.
Okay, I think that this is a reasonable request to make this a viable dwelling. I don't think it's a detriment to the neighborhood. And I guess I'm in favor of granting the special permit.
Thank
For the
you.
accessory dwelling unit.
Yeah, for the accessory dwelling, yeah.
Okay. All right. Well,
I would,
if no
I would
one-
agree with that.
Okay,
I would agree
thanks,
with what
Paul.
Mark said in terms of the approving the special permit with site plan approval for this, the accessory dwelling. I mean, the property is big enough to house it. It's not going to impact the neighborhood or traffic or anything else.
Fabulous, thank you. Dick, did you have something?
I just want to say I agree with Mark and Paul, so
Okay,
I'm in
fabulous.
favor of this.
Okay.
And,
all
and
right.
as part of the special permit for the ADU, you're also approving the site plan.
And right.
Right, yes. Okay, so do I hear a motion?
So I'll make a motion to grant a special permit and a special permit with site plan approval for the property at 11 King Street for the construction of the increase in size and also the addition of the accessory dwelling unit. Does that cover it?
Yep, not to exceed, well, yeah, not to
Oh.
exceed 700 square feet.
Square feet, right.
The motion, do I hear a second?
Second,
Okay, motion and second, roll call. Mark,
Aye.
Dick,
aye.
Paul,
Aye.
Brad,
Aye.
Fran, aye. Okay, so now we're on to the 399 Hudson Street duplex on the 30,000 square foot property located somewhere on my floor.
I have that system too.
Yeah, yeah, it's crazy. Okay, so,
I hear you, friend.
yeah, all right, so, I don't know, I mean, I think it's a reasonable project. I am thrilled actually to see a duplex that is not 4,000 square feet on each side.
Right.
That it is actually modest, living in a 2,100 square foot home myself. I do strongly agree that a deed restriction limiting to 6 bedrooms is important. And my understanding is bedroom does not necessarily be defined as closets or doors or things like that. It is if somebody sleeps there. And actually there is language on other deeds, specifically the candle factory, where it specifically says that that third room cannot be used for overnight stays. So as to know that it's not a bedroom, as opposed to whether you have a closet or a door on it. But I don't know exactly with the language, but we would want some type of deed restriction for septic purposes. But other than that, I think it's, it's not bad.
I tend to like also the double entrance, just because you're only really going to come out of either one entrance or the other. I don't think you're going to not have people exiting on both of them at the same time. So I don't think it complicates the traffic.
Right. True, because they're separate housing, so they're gonna come and go on their own schedule. Yep,
Yeah.
okay. Any other concerns or? All right.
No.
All right, well, how do people feel about making a motion? This is for a special permit through the groundwater protection overlay with the site plan approval.
I move that we grant a special permit with site plan approval for the property at 399 Hudson Street. This is specifically for the impervious cover of the driveway.
No,
Okay.
it's for the use as a 2-family in the
Family.
groundwater
Okay. All right.
overlay
So
district.
for the use of the 2-family in the groundwater protection overlay district.
Okay, and included in that motion, we require a deed restriction limiting to 6 bedrooms for the entire project.
Yes.
And
you.
We would also include the comments from the groundwater advisory committee.
Right, and that And Fred actually specifically asked for one permeability testing be done on a regular basis. And I don't have all the language written, but I would want to make sure that that is in there because that seemed to be something that he really wanted, and he's been so good to us tonight.
It's in the letter, and it's
Okay.
one permeability test in each area that's going to be used for infiltration to confirm the drainage analysis that they have to make some assumptions to do it. So they have to do that before they get their building permit.
Right.
Thank you for that. Okay, so Mark has made the motion. Do I hear a second?
Second,
That was Dick Rand. Okay, roll call. Mark,
Aye.
Dick,
aye.
Brad,
Aye.
Paul,
Aye.
and Fran, aye. Okay, just going up there. Okay, now we're up to 17 Mayflower. Oh, okay, so 17 Mayflower was a variance to do a carport on an existing garage with 11 feet from the side setback as opposed to the 15 that is required.
Being that there's already existing impermeable cover there, putting a roof over the over the driveway, I don't see as a terrible imposition. Nor does it change the nature of the neighborhood or impact the neighbor to any great extent.
Mhm.
Okay. Is
Yeah,
that
that
a
was my
motion?
initial. Oh, no, so that's just to add on to that. That was my initial question. Like the driveway is already there. So it's nothing new. So I'm in favor.
Okay, fabulous. Okay, so do I hear a motion or more information?
I move that we allow a, let's see, imposition into the offset of 5 feet on the side setback for the property at 17, what is it again?
Mayflower.
Mayflower.
Okay, so that's the variance for the setback.
Right, right.
Okay,
Second,
okay. That's a motion and a second. Mark,
Aye.
Dick,
aye.
Brad,
Aye.
Paul,
Aye.
Fran, aye. Okay, we're bumping over 50 Southwest. They're continued. So now we have the 329 West Main Street, the Newbridge Granite Corporation's special permit site plan approval for the granite countertop use of sails in the front, preparation of the countertops as an accessory use in the back, in an otherwise, yeah, okay. Nope, all right, that's it. And what is it? It is, okay, so it's a special permit with site plan approval because of the groundwater protection overlay district 3 and the use of chemicals inside the bay. So this has been a while. What do people think? And I'm sorry that it's this late. I assume the best thing to do is to try to wrap it up, right?
Right.
Because otherwise we have to have a meeting just to do these last two petitions. So if David is good, we have like 15 minutes or so, David?
David is good.
Okay, fabulous. Thank you. All right, so what is, I think some of the requests or the recommendations that Mr. Creamer wrote in his letter have been addressed and or will be addressed. So I think that is important. I mean,
I guess overall, I'm in favor of this because one, it is a retail site. It's primarily a retail site. I think the process that is the industrial process of polishing and servicing the granite is going to be fairly restricted to inside the building. I don't think it has a risk of contamination. I'm convinced that, their major chemicals seem to be epoxy, which if you spilled that on the concrete floor would tend to seal the floor before it got out into the groundwater. I really feel that this is a minimal impact, a minimal danger to the area. And the only real concern I can see they have is the noise, and I think we've got that handled.
Okay, thank you. Other members and/or alternates, you're welcome to chime in. You don't have to stay silent.
Yeah, I guess, Madam Chair, if I may, so just to kind of piggyback someone off Mark, I think when I look at this case, the fact that a majority of the process is going to happen within the building, the amount of chemicals is significantly smaller than any other anything that's come before us for this property. I think that we just need to be careful with the conditions that we apply to this. Obviously, the hours of operation, the spill package kit that I think, Madam Chair, that you had mentioned that we weren't necessarily aware of. Limiting the chemicals, I think it was to 45 gallons. Fred, if that's confirm that, right? Yep. I'd also like to have the special permit only to the tenant, which is Newbridge Granite, and only to the portion of the building that they are looking to start the business today, which is if you're looking at the site plan, just sort of that small piece there where it's the showroom in front and then the small fabrication. And then I guess, the other point is whether or not they can have slabs outside. I think that saying that they can't have any slabs might be too restrictive. But I'm not sure if there's a number or a certain square footage. That's something I'm still kind of trying to wrestle with. But
I guess if I may, I'd be happy with a 200 square foot restriction, which is if you think of it as 20 by 10 area for slabs. If they can't organize it within 200 square feet, something's funny.
So I guess do you think a better thing? Oh, sorry, Fred. I was gonna say, do you think it's better to limit by the square footage or the number of slabs? That would be the only, if you were to try to put a condition on it.
I would limit it to the 200 square feet just because that way, it's easily measured to say, yeah, you're spreading this all over the yard, keep it contained.
Okay.
Fred?
I just throw out for point of reference that 200 square feet is about the size of a parking space. So,
okay.
And if you contain it to the 200 square feet, because the slabs could be different sizes, so there could be 3 small ones or 2 big ones, or if you wanted to have them gate or fence the 200 square feet so that it's in the same area all the time, it's not sprawling anywhere, you might consider that as well. And I would remind you that you could, if you choose to, require the dedicated 13 parking spaces that the bylaw says they would need for the size of the space they have.
Right. And should the business boom and 18 months from now they realize they need more space, they may decide to relocate. I mean, they're tenants, so that they're not stuck there. They may find that they need more retail space, not necessarily prep work, but they can always come back and ask for additional relief, I would guess. But I think 200, knowing that 200 square feet is only a parking space, I think that's incredibly reasonable amount to start off with. I mean, for them to try to actually fill, because I think that would be good business. But I do like the requests that were in the letter, as far as I would include that Bob will do the baseline sound and monitor it for, before he issues build permits and things like that. I think that we should have a provision, if it's approved, that the grant cutting and surfacing and whatever else they do, treatment is done with the doors closed. That they do have that MSDS, which Fred referred to. Yeah. And then the 13 parking spaces.
Which the parking spaces are already there. So,
Right,
Yeah.
right, yeah.
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 yeah, I mean, I think that the, you know, and then, you know, just the original site plan, even though it's very basic, is fine. I think the newer site plan, you know, Fran, to your point earlier in the meeting about looking at this case solely based on New Bridge Granite and the business that they are running, I think that the paving of the side lot is not, does not flow with what this case that's in front of us is trying to get approved.
Right, exactly. All right,
So, you know, I think that, you know, the original site plan, even though it is very basic, again, I mean, to all of their business operations, by and large, is going to happen within the building, right?
Yep.
They're going to have the showroom, they're going to have the small amount of cutting, and then the small amount of chemicals that they're going to be using, which has already gone through all of the appropriate boards and steps and everything else. You know, they already have all the parking that they need. You know, this other site plan is, even though is probably more detailed, just does not sort of fly with this specific case for New Bridge.
Okay, and do people feel reasonable? I know they said that they were hoping to have business hours between Monday through Saturday, but limiting Saturday to the retail only so that there's no production in the back end?
Sure, if that's
Yeah.
a restriction, that's a reasonable restriction, and if they have a problem with it, as you say, they can come back and ask us for Saturday processing hours, but I don't think it's necessary at this time.
I agree. Yep.
I agree.
Same.
All right, so now who wants to wrap that up in a nice neat bow with a motion one way or the other? Come on, we're doing.
Someone can, I mean, if you want, I mean, it's all here on tape. I just
Right.
wrote it all down.
Okay.
And if someone just wants to so move it,
I move that we grant a special permit for the property at 399
Oh,
West Main Street. Excuse me,
329.
sorry, 329 West Main Street. Subject to all the conditions we've discussed as far as 200-foot square foot outside storage in the rear of the property, 13 designated parking spaces on the property, only processing operations on Monday through Friday
Indoors.
indoors with the garage doors closed.
Doors closed. Yep.
and what about,
and a sound survey taken before so that we can compare excessive sound later.
and the outside storage, do you want that fenced or?
I don't think so.
Okay.
I want to know where I can get some free granite if I need it.
When you're feeling strong.
Yeah.
Don't forget the comments from the Groundwater Advisory Committee. There
I
was
ha- Yep, they're in here.
Watch out for the killer watchdog they've got.
Oh, my
second.
son. Okay, so that was a motion by Mark, a second by Dick, and a roll call. Mark,
Aye.
Dick,
Aye.
Brad,
Aye.
Paul,
Aye.
Fran, I. Okay, moving on to the first and last of the agenda is the 5 Barefoot Road. So I can tell you, I could argue this either way.
So we're merely deciding whether the whether Bob's evaluation of it is correct. Is that?
Bob's determination was that the 100-foot setback required by our bylaws when industrial abuts residential is reasonable regardless of the use.
Mhm.
And the applicant is saying, well, because we're doing a daycare under state law, that reasonableness may not apply if this use would have naturally been allowed within the residential area anyway.
Mhm. Okay.
But
Yeah.
I
Well,
mean,
I guess the question is, that would, if the board was to not grant the, basically disagree with what I wrote.
Right, yeah,
And I won't take offense, I promise.
yeah.
Right.
The question is, the original setbacks that are in the zoning book,
Mhm.
which is the 20 and 40, those are back into play, if I'm not
Right.
mistaken.
That's correct.
And currently, the way they have the lot laid out, it does work.
Right.
Okay.
So, one of the things that I thought was, it's a reasonable thing because it went to town meeting. And unfortunately, you guys had to kind of deliberate this whole thing through. Because that's a pretty tough call for me to just say, go ahead and build it.
Right.
Yeah,
You know.
no, I
No,
understand.
I think
Yeah.
that your interpretation of our bylaws is just. What
Yeah.
they're saying is the intention of that is to serve the purpose of separating industrial from residential. In this instance, it's not an industrial use. And if
Right.
it was going to be in a neighborhood, it would have just the normal setbacks for the neighborhood. That being said, in our neighborhoods, we don't have commercial style daycares. They're
Right.
the ones that they listed. I think most of them were out of our area. I actually did my own little research that 9 of the 18 in Northborough, 2 are in churches, 3 are in schools, 3 are in the business area along Route 20, and 1 is in a neighborhood and it's in a person's house. So this daycare would not be in our neighborhoods, right? Because of the size of the structure. But the concept of daycare can be in our neighborhoods with setbacks that are much less than 100 feet. So I think one of the people in the audience did say, well, in court, you don't know which way it will go. And that's absolutely right. And that's why there are courts and there are competing attorneys, right? Because you interpret it and then you make your argument and you hope you sway the judge or the jury. So here we are.
When it comes to zoning, you look at it in any given court case, and on any given day, you can have a decision one way or it's a decision the other. So it's a big load of a gray area.
Yeah. So, there's also something to be said about if you can buy a piece of property for $10,000, what are you shoehorning into it, right? I mean, but that being said, you work with the system and that's your job, right? We see that with pork chop lots with houses, and you say, how are you getting that in there? So again, you can go either way.
My own sense is to not override our building inspector on this.
Yeah. I mean, I think it's a safe decision because again, either way, something may be built there someday, and maybe nothing is ever going to, a bus stop. If we start going with mass transit, you can put a bus stop there. I don't know. I mean, I could be, I would go either way if somebody had, wanted to go and make a motion.
No, I just want to just add to, sorry, Paul, what you were saying, Mark, like not to override the building inspector. I mean, we're not discriminating against the use. These are the bylaws, and it is a distressed property.
Well, that's good,
And so I think they're just trying to shoehorn it in, put a round peg in a square hole, and trying to use anything they can to build on this lot. But again, it's not like, nope, we're not doing daycares. We're not saying that at all. And the building, the enforcement officer didn't say that at all either. So.
Right. I mean, having a daycare in that area, not on that piece of property, but in that area does have merit because you see them on Cedar Hill Street in Marlboro, see them in other areas because you're near your kids, which now you're really near them. But yeah, so all right, well, unless
I'd just like to say, I think this is just a Hail Mary pass on his part to utilize a piece of land that's really not usable. And he's using the Dover Amendment to circumvent and the child care facility law to circumvent the fact that he's got an unusable piece of land, and he can use those 2 exceptions to try and get his way. And when in fact, we have no opposition to a child care facility. The only thing is that he's using it. He's so close to the residential area. It's so large. I support Bob.
Okay, so do I hear a motion? I told David we would be done by 9:45. It's getting close.
I motion that well, it's always done, I always heard in the
So you're denying
affirmatives.
no, but you're denying the appeal
Appeal,
of the,
okay.
if that's what you're motioning, you're motioning.
That
to
is
deny
where I
the
want to
appeal.
go, but I'm wondering if we should say, we should motion to override to sustain the appeal and then deny it.
Oh, no.
No,
doesn't matter. Oh, I think I would say, that we deny the appeal.
deny the appeal.
I-
Okay,
I would-
then I would motion to deny the appeal.
Second.
Are you, Kathy, you okay with that?
Yep.
Okay, all right. So there's a motion on the table to deny the appeal by the applicant of the zoning enforcement officer's interpretation of our zoning bylaws. And it was seconded. And so a roll call. Mark,
Aye.
Dick,
Aye.
Paul,
Aye.
Brad,
Aye.
Fran, aye. Brad, you look like you're in outer space. I mean, I'm in the dark
Well,
and you're out
I
of
got
space.
thrown out of the office. Little kids are going to bed, so I'm just sitting down here. Yeah.
There you go. All right, so I think that is it. I don't even want to talk about anything else unless somebody has something that they really feel we need to talk about.
Did anybody look at the minutes?
I looked at them, but I don't think we have time.
Please, God, no.
I think that's the
I moved
equivalent
that
of a
we
motion to
adjourn.
adjourn.
I second that.
Okay, roll call. Mark,
Aye.
Dick,
Aye.
Paul,
Aye.
Brad,
Aye.
Fran, aye. Thank you, everybody, so much. Everyone in
Leslie,
the
aye.
audience, thanks for hanging out with us this long.
Bye,
Now
guys.
en-
Good night.
enjoy
See you
what's
next
on
month.
TV.
Thanks.
See you in a few weeks.
Night.
All right,
Yep.
take
Yeah,
care.
All right, bye.
Bye.